Welcome to the Foul Play YouTube channel. Open mic number 161. Hope everyone's doing well today, wherever you're located in the world. United States, Europe, Australia. Today we have Travis Williamson back again to talk about the post-conviction process, answer some more questions, obviously. And, who knows what else we'll talk about. But that's the main topic of today's open mic. We've already had some really, really good discussions with Travis. He's explained a hell of a lot in terms that I think everybody can get a grasp of and understand. And we're going to continue down that road today. So, as we normally do, I'm going to say hello to everyone here in Discord so we can get voices for those that may not know who we are. And you can, kind of recognize them. So, first up, we've got Alice from across the pond.
Hi, Jack. Hi, everyone in panel. Hi, everyone in chat. It's great to see you all. I'm feeling a little better. It was an allergic reaction I had. That's why I couldn't make it last night. I'm here tonight. Might not stay long, though, because I'm still feeling a bit yucky, but glad to be here. Glad that Travis is back with us and looking forward to what we've got tonight. Thanks, Jack.
Yep, thanks for coming, Alice, even though you're not up to 100%. Appreciate you coming. And then, of course, we have Cherie, another legal mind.
Hi, everybody. Welcome to Open Mic.
Hey, thanks, Cherie. And then we have JD.
Hi, everybody on panel, and hi, everybody in chat. Good to all, and looking forward to tonight.
Thanks, Jay. And then Sister Rhonda.
Hey, brother. Hey, I think everybody on panel. Great to have Travis back again. We love your wisdom and knowledge. And welcome to everybody in the chat. I know everybody in the chat also really appreciates what Travis is able to share with us and teach us. So
Absolutely, yeah. And he's a busy lawyer, and for him to take his time to do this is much appreciated. And then, of course, thank you, Rhonda. And then, of course, we have Travis. How you doing, Travis?
I'm good. Sorry to hear that Alice had an allergic reaction. Understand she has to leave early. Hope she feels better soon. Thanks for having me back. Is this part 3 or part 4?
Part 4.
Jeez, they're running together. Okay. Well, I'm looking forward to what we have to cover and see if we can answer. We answered all the questions that were previously submitted. So if people have questions during the presentation, everybody type them in there, and I'm sure somebody will grab them and let us know. And I can't really watch chat too close, but I saw Scooby the dog in there and some other familiar faces, and thanks for joining us. And that's all I got for right now.
Yeah, we'll try to. Yeah, everyone that's in the live chat, if you have a question, please put a Q and then ask your question. And one of us will try to monitor. Well, we all try to monitor, but Alice is really good. Rhonda's really good, and others, and Cherie. We'll try to get those questions to Travis. I'll try to watch and pin them, or one of us can pin them, and so we can get to them. All right. So, hey, we had somebody else join here too. I saw.
Hello.
Hey, it's Tuco. How you doing, Tuco? Thanks for coming.
Hey, hi there. Yeah, sorry, nice to be here. Yeah, so I think I've put a key in the right place. Have I opened my text?
Chico's got a question in the section that you guys set up for open mic, and it's a great question, and I'll get somebody to dig that up during the presentation when we come to our first section on questions. If someone, it's right at the very bottom. I'll pull it up.
Okay. Yeah. Yeah. That
I
room.
think I
Yeah.
see it
Yeah. That room that.
right between
I'll s-
double D.
Yeah. I'll set up a room on our Discord for people to put questions in for Travis, and they just add them in as they come along. And I know Kel tries to grab them, and Travis will, tries to answer them. So yeah, we'll get to it. No problem.
Yeah. Yeah, that one came in since last time, and it's about the RAV and right, Tuco, and that comes up a lot. So we'll get to that when we come to the first little segue on questions.
I get you. Okay, nice one. All right, then, thank you. So if I've got another question, do I put a Q in here? We'll come back to it later. Into the open mic questions for
With that, or
Travis.
you can, or you can put it in the live chat on YouTube. Either one.
Oh God, yeah, I've not got YouTube open properly. Right, okay, right. I'll be quiet then. I'll let you guys crack on. Thank you. I have got a question for later, though, about calls on the 4th.
Sure.
Will I just ask it now? Will I just come out and ask it now, just so you got something to think about? Well, a quick one.
Well,
No, it's cool. It's cool.
we'll get to it here shortly. I promise.
Okay, yeah, cool. All right then. Right, I'll be quiet. Thank you. Thank you.
Thanks, Tuco. So, just so we're not rude, Rhonda, can you say hello to everyone that's joined us on the live chat right quick? And Travis,
sure can.
I'll pull up whichever document you want me to pull up first. You want me to pull up the PDF file questions, or you want me to pull up the PowerPoint?
Per Kel, who you and I had a chance to visit with before we started, we covered all of the questions in that document.
Oh, that's
So,
right. Yeah.
pull up the one that I've mislabeled as part 3, the PDF, please. Thanks.
All right, Rhonda, go ahead.
Okay, we're going to start at the very top, or my very top, with our dear friend, panel member, and team member, Neverly Darlin. Welcome. She's not going to be able to join us on the panel today, but she is listening and in the chat. Dark Side of the Moon, who's be dropping links. Inexplicable Susan just got home, it looks like, about a half hour ago, and she said she's going to be listening in. Yeah. We have Passive Bear, Gloria. Hey, Gloria. J Jax is in the chat. JD is in the chat and also on the panel. Scooby the dog. Hey, Scooby, we are so happy to have you here. Travis Williams is in the chat. We know who that is. Ian Rose is in our chat. Welcome, Ian. Lord Bucco. Welcome, Lord Bucco. Nan's Life 7. Hey, girl, great to see you here. And TTM Fangirl. TTM is here. Jack's neighbor. Clive Coolidge is here. Welcome, Clive. Rumor Has It is with us as well. And let's see, Ronald from the Ozarks in Missouri is with us. Hopefully your humidity is cooling down a little bit for you out there. Gloria, the song immediately starts running through my head when I see Gloria's name. And let's see what else. Alice is in the chat as well. We're all certainly hoping that Alice can recover quickly. We miss her when she's not with us. And Checking Convictions is in the chat. Rhonda SD, my beautiful friend from the UK, welcome. And Nacho Loco Tuco.
Nacho Loco Tuco.
And he's also on the panel with us this afternoon.
You missed Wooden Pallet, Pete Moss. I'm sorry, Pete Moss. I can't help myself when I see that. If you don't like me doing that, please just say and I'll stop. But I can't help saying Wooden Pallet first.
Why don't you just start calling him Pallet?
Yeah. Pallet Pete.
Yeah, Pallet Pete.
Pallet Pete.
Okay, thank you.
I think I got everyone besides that, so
Yeah.
thanks.
Yeah, thank you so much. There's rumor has it. I don't know if, okay, I guess you got her.
Yep, we got rumor.
Okay.
I think we got everyone. If you haven't already on your way in, before we get involved in our conversation here, please hit the like button. We're about half of what we should be versus watchers.
And then go over to Rhonda's channel and give her a sub. We're trying to get her to
Yeah,
500. Trying to get
and
her to 500 so she. Go ahead.
Yes. Sorry. I just got real excited when you said that. I just learned yesterday that I'm at 450 subs. I don't know why, but that's like another magic number for me. So
she needs 50
run
more,
over
so she needs 50 more so she can get a community page, so she can start sending messages out. It's always nice to have that.
Yes.
I mean, it's just another
please
way to
help me out.
communicate. It's another way to communicate, to people that listen to your channel and so forth. So that would be nice to have. So give Rhonda a little bit of love too, and give her a sub. So, all right. Thank you so much, Rhonda. All right, Travis, I've got it up on the screen, and we can start however you like to do it. We're open. The floor is yours, sir.
Okay, so I mislabeled this. It's part 4.
It's fine.
Hopefully 4, but after this one, I want to, whenever we do another one, I'm going to do one with Cherie on the current cases out of the 7th Circuit and the Wisconsin Court of Appeals and the Wisconsin Supreme Court, where they actually ruled in favor of but that's what's coming up. So just to review, we've covered the normal appeal process after you go to trial and you lose. What's the normal appeal process in Wisconsin? And then what can you do post-conviction, direct appeal, and then if you lose your direct appeal, what can you do in 97406 motion, and which is where we're at now with Stephen's case. And we kind of went through the history of that and talked about some of the main things that you can use in a 97406 motion. We covered how you get around or hurdle the procedural bar part of it, and what Zellner was able to do to get around the procedural bar hurdle and what she wasn't, and why that was, and that what the typical claims are in a 97406 are ineffective assistance of counsel, and we covered what the requirements of that are. Brady covered the requirements of that. And the third and final one is new evidence. And fortunately, we had a recent case in June come up that's interesting because, so we're going to use this to explain this third typical issue you can raise in a 97406, new evidence. We're going to use this case because what it really boiled down to was the credibility of witnesses. And so, as everybody knows, or most people know, what's the third 97406 motion, the one that was just recently denied by the circuit court and has been appealed to the Wisconsin Court of Appeals. That 97406 motion centers around the credibility of two witnesses, one more than the other, but can somebody on the panel remind everybody who those two witnesses are?
Thomas Sawinski and Tom Baresh.
And so there, you've been following that closely. There's already been plenty of comments about whether one or both have any credibility, if they're one more than the other, or why one may not have credibility. And so this case I happened to come across recently. We're going to kind of go through it a little bit. And if you can get where it says paragraph 15 to obtain a new trial, if you can make sure that's in the middle of the screen, Jack.
What page is it on, Travis?
It's going to be on page 1, and then it's got the paragraph symbol, and then 15:15. It's basically the second full paragraph on page 1. To obtain a new trial based on newly discovered evidence. There you go. Right there's good. To obtain a new trial based on newly discovered evidence, Jordan must establish by clear and convincing evidence that, 1, the evidence was discovered after conviction. Otherwise, it's not newly discovered, right? Number 2, he was not negligent in seeking evidence. And some of these things, you will be familiar when you hear them, because there was a lot of discussion about these in the briefs on the second 97406 motion and even the third. Third requirement is evidence is material to an issue in the case. Number 4, the evidence is not merely cumulative. That's a very important one. And then if those 4 criteria have been established, we then determine whether a reasonable probability exists that a different result would be reached in a trial. So that is critically important. Reasonable probability exists, different result. Can scroll up down to the top of page 2. And we're looking for the yellow highlighting. Bingo. Okay. We reviewed the circuit court's credibility finding for clear error. So that's the standard of review, is what we call it. So where a circuit court actually holds an evidentiary hearing and actually makes findings about credibility, that witness X was, very believable, or witness Y's credibility was challenged, but I still believe witness Y, or witness Z lacked no credibility. And we're going to get into some examples of that down below. So they make those findings, they go up to the appellate court. The appellate court is not going to reverse a credibility finding unless there's what's called clear error. And the only time you're going to have clear error is they've just mistake one witness for the other. They say, I didn't believe Mr. Smith because he said the car was blue. And actually it was Mr. Jones who said the car was blue. Absent something like that, they're just not going to disturb it. Now, we don't have this in the current appeal that Stephen's bringing through his lawyers, because there was no evidentiary hearing for there to be credibility determinations. Is everybody with me so far on the panel?
I am. Somebody else may have questions, Travis.
I'm good.
Yeah. Okay. So it's.
I guess just one quick example is like, when we got the information about Sawinski's affidavit, that's all we had. And then we come to find out later there was a phone call that was withheld that he says he made. His girlfriend or fiance at the time also submitted an affidavit, and she said, "Yeah, he did tell me about that call. I remember." and what he saw, or something to that effect. So that gave him his story at least some credibility. Now there's other questions, but
Yes, absolutely. And so, and I'm glad you brought up that example, Jack, because that's important. So there is a standard to get, sorry,
you're fine.
Boudreaux's hearing something.
Well, he's our dog.
So there's a standard to get an evidentiary hearing, and then an appellate standard if the circuit court refuses to give you an evidentiary hearing. And they're not supposed to be looking at the credibility at that point unless the trial record establishes clear and convincingly that you're just not entitled to a hearing. You know, it's a bogus, bad faith argument. There's no way on earth that you're going to get a new trial based on that avenue. For example, the issue might be procedurally barred. But once you lay out where you're going, the court should say, yeah, okay, well, conceivably, assuming these people are credible, you know, there could be something to this. They're not supposed to make credibility determinations until they actually have the evidentiary hearing. And so I'm glad you brought that up, because that's very important. Go ahead.
See here, Travis, here in the UK on the case that I'm working with Luke Mitchell, the Crown's star witness completely described what Jodie was wearing completely wrong. Her description, driving by at 30 miles per hour on a corner, she said that she's seen a guy and a lassie standing in the aisle, and she had a blue top on, and she had dark jeans, and she had long hair, and the jumper was blue. Well, Jodie wore a black hoodie with a big orange Deftones symbol on the back of it, and there's no way that you could miss that sign. But they still took her word about this blue jumper and black and dark jeans and things, and she was the Crown's star witness. But when Jodie's body was found and the clothes that was found with her, it was her black Deftones top. So if her back was to the star witness, then there's no way that she would have missed this big orange symbol on the back of Jodie's top. But they still used her as their star witness, you know.
Yeah, and so testimony at trial, so somebody testifies, for example, that they saw a really big bonfire somewhere, or they testified that the murder victim, last time they saw the murder victim, they were walking towards a residence. And then, so on appeal, you really, even in a 974-06 motion with the circuit court, very difficult to attack the credibility on that unless you have something like forensic evidence that just shows that they're lying and it's completely false. And that would qualify under new evidence if you had that. Or if the defense attorney was asleep when the star witness was describing the bonfire or what the person was wearing or where the murder victim was headed when they last saw them. That would be ineffective assistance of counsel. Or if you had maybe another witness that said, oh yeah, I saw the bonfire and, it was a normal bonfire, 2-3 feet in the air with some, typical smoke. There were some tires in it, so there was black smoke. Or, no, I saw the person driving down the road, leaving the property, and that information wasn't turned over to defense counsel prior to the trial, even though it was contradictory to the star witness, then that would be potentially a Brady violation. But you don't really go in on appeal and just on its face, by itself, isolated, you can't really go in and say, this is preposterous. Because, and the reason why that is that it's for the jury to determine credibility. And hopefully they've been given a full picture of the witness, either, their bias or their, lack of recollection, the fact that they've exaggerated, whatever it might be. That's the role of defense counsel, is to, through cross-examination, to show those weaknesses. And where the system breaks down is if defense counsel doesn't do a good job of bringing out the whole story from the state star witness. And because you can't appeal based on what the testimony was, and in essence what you're arguing is the jury shouldn't have believed that person. It's not a grounds for an appeal, because it's up to the jury to determine the credibility and as the finder of fact. And so I'm glad you brought that up. Go ahead, Jack.
Just a quick comment, and you can talk about it if you want. And this is specifically about Sowinski, right? So, back when he submitted his affidavit, we're all scratching our head and everything and saying, we need more. We need a phone bill to prove he made this call to MTSO back in the day. And of course, we didn't have anything for months and months, and finally we did. But the problem, again, when he made, of course, we only have half the call. We don't have his connection to Sergeant Singlub. The call gets transferred, or a new line gets created, and we don't have the other half of that call. But when he, I think back in the day, if I'm remembering correctly, he did not specifically identify Bobby until after he saw Making a Murderer, which is, of course, years later. Now, we don't know what he said to Singlub back then, but if I'm remembering right, he didn't identify Bobby specifically at the time. And we all know, and you probably know it far better than the rest of us, witness identification is often, really often, terrible. It's just the way the mind works a lot of times. That's a comment and a question. If you want to comment further, you can.
So from what I understand, there's been multiple statements, and there's been information added, more information in subsequent ones. There's I don't know if there's contradictions between affidavits, but let's just say there are. So those things should be explored in a evidentiary hearing in the state. That person or, those witnesses would be called. Kathleen would bring out the information she wants to bring out. Presumably it'd be consistent with the affidavits, but you don't always know, and we'll see that in a minute. And then the state could cross-examine that person and say, well, in this affidavit, you didn't put this, or in this affidavit, you now have that, and then it would be up to the circuit court to judge the credibility. But you're not supposed to have credibility being looked at to determine whether you're entitled to an evidentiary hearing or not, because for a circuit court to deny an evidentiary hearing, the circuit court has to find that the record on appeal conclusively establishes that you don't have a right. Don't know if anybody recalls that from the prior episodes.
Yeah.
And then where the big issue is that what the circuit court, in her opinion, wrote in terms of, nobody saw a potential third-party defendant with a key.
Yeah.
I'm trying to keep names and personalities out of that because we have so much other commotion going on with scam. But, just putting this down to brass tacks, that, the third-party defendant, nobody saw him with the key. Or, well, if you think about it, cases where we just know it turned out to be somebody else, and the case I worked on the outside, it's a periphery, the West Memphis 3, instead of the 3 teens that were charged and convicted of the murder of the boys, the stepfather, his DNA popped up later on as part of post-conviction process, and but if you took, assuming there wasn't that DNA and there was some other object or some other witness came forward and said, I saw this stepfather in that area between this time and that time. And then to have a judge come in and say the things that this circuit court did, well, you didn't show this and you didn't show that. And I mean, no one would ever be able to get a evidentiary hearing absent DNA evidence. So that's what the issue on appeal is. Did that answer your question, Jack?
Yeah, it did. And basically, I remember, last time we talked that with what she did, and I'm speaking specifically of Judge Angie, it's like it just kind of makes my head hurt when she would make that statement that this person wasn't seen with a key prior, when he's got the car, a couple of days after this missing person is reported. It just makes my head hurt to think that there's some kind of wiggle room around that. I don't know. I didn't agree with her justification at all. That's just
no, and you're looking at it the right way, and other people have commented, about the different comments that she's put in the opinion, or it's not an opinion, it's order. And no, there's a lot of people that are thinking that way, but so using the circuit court's analysis, that means you'd have to go out and do things like putting aside that the witness says he saw the vehicle being pushed down the road, a matter of days after the date of the incident. But putting aside that for a moment, because that just makes no sense that, it doesn't establish 100% that he's the murderer because he's pushing the vehicle, but look at all the questions that it does raise. And we're going to see in a minute what, the narrative the state puts on how this all fits in. But you have to, go out and hire an expert. Yeah, I work for the Toyota company, and that particular model of vehicle has a steering wheel lock, and without the key, you would not be able to push the vehicle down a road, unless you disabled or bypassed the steering wheel lock, which would cause considerable damage. But you just looking at what all do you have to explain in your motion. It should be enough that, hey, I've got a witness who says third-party defendant that we named and we wanted to bring into not a third-party defendant, third-party suspect into the case, and we were denied. Not only that, he tried to contact law enforcement to report what he had seen. That should be enough, but it's not. But those are the things that are going to be raised in the appeal when the opening briefs filed, which is going to, without it, if they're assuming no extensions, should be due sometime in November.
Well, like I think you talked about the last time, it wouldn't be surprising if Casey asked for an extension.
I wouldn't be surprised at all. There's a lot of material to cover, and of course she has many other cases, and her partner that does a lot of the writing, who knows what he's got on his docket. And from what I have seen, she's always asked, and the other side's agreed, she's always asked for at least one 30 or 60-day continuance extension.
Right. Rhonda, is there a question? I see you pinned something from Graham.
It looks like it's a comment, mostly, but a logical one. He says, if the prosecutor and detectives are not held accountable for wrongful convictions, there's always going to be wrongful convictions. I thought that was a really good point.
It is. Well, I think that I'll let Travis continue, but I think that is another part of what we have discovered, not only in the Avery and Dassey cases, but many other cases as well, where the police, they kind of take this judge and jury approach in their investigation, help the case a little bit here, help it a little bit there, because in their mind, this person did it. So, but things are a little shaky. They look a little shaky as far as when you go to trial, can a prosecutor get conviction? And we see that play out in so many cases. That's all I got.
Well, Jack, as well as I do that that's exactly, only to a very egregious level, that's exactly what happened in Daniel's case. So
Sure.
The detectives were determined that they were going to convict him. They were going to make him a serial rapist and make sure that that he was convicted and that the conviction
Oh,
stood
I
and
I
it,
think if, anyone that goes through that material can clearly see that. And wherever their orders came from, clearly I'm convinced that that came from their superiors, from wherever up in the food chain, that he was going to go down. Period. End of story. And that's what they made happen. I see it, but same with
well, and I'm trying to show it.
oh, you are. And same with Avery, and then by extension Brendan.
Yeah,
Same thing. Brendan
yeah,
got
oh
roped
yeah.
into this whole freaking mess. So anyway, all right, Travis.
Okay, so right underneath that highlighted part's a heading, ineffectual assistance of counsel, which we've already covered, but we had a lot of questions, and pulled this up for Cherie. Questions about if there were new post-conviction counsel for Stephen, could they argue that current 97406 counsel was ineffective, and either the second motion for post-conviction relief, the 97406, that was the big one. Could they go in and say, counsel who represented Stephen Avery on that was ineffective? And it looked pretty clear, but then there were some other cases that were kind of wishy-washy about it. But here it's the second sentence. His ineffective assistance of post-conviction counsel claim flop because he had no right to any counsel, let alone effective counsel, on a 97406 motion. C. Coleman v. Thompson. So, Cherie, this is a June opinion, and so, I think it's pretty clear that there would not be a way to claim ineffective assistance of Zellner's firm on post-conviction. And I don't know if Cherie has any follow-up comments or questions about that, but I ran across that.
Oh, I was thinking that you had said there was one that was the opposite way. I must have misunderstood. But I guess that makes sense if you don't have a right to counsel at all anyway, so.
Well, on what I was referring to, and I probably wasn't very clear about it, is so on direct appeal, you have the trial, and then if you're complaining, so you have the trial and you lose and you're found guilty, there are some motions you can bring for a new trial based on a number of things. And if you're claiming that the attorney, and they call those post-conviction motions in Wisconsin also, but if you're claiming that the attorney, and Stephen had these post-conviction motions, he had an evidentiary hearing after his trial and before they filed the direct appeal. So if you want to claim that those attorneys that filed the motions for new trial were ineffective in the way they did it, you file that motion with the circuit court. But if you want to file a motion for ineffective assistance of trial counsel, I probably have this backwards, you file that motion in the Court of Appeals, and they make that determination. And it's a process that's unique to Wisconsin. So that's in the direct appeal context. But once you exhaust your direct appeal, you go all the way up to the Supreme Court of Wisconsin, or you're denied review by them. Then your only avenue is under 97406, like we're seeing here. and you cannot bring a ineffective assistance of counsel for your 97406 motions. And I don't doubt that I made that confusing, but hopefully finding this part of it in a recent case clears that up.
Yes, it does. Thank you.
Top of, go ahead.
Yeah, Scooby the dog seems a little confused about the not having a right to counsel, and I think that I mean I understood it. I think it's just under certain conditions a defendant or a prisoner or whatever wouldn't have a right to counsel. Is that what I'm understanding you said?
So let's go back to that Coleman v. Thompson case. So before Gideon v. Wainwright, which was a case in the 60s down in Florida, you didn't have a right to counsel in state court. Most provided counsel. The only time that what the Supreme Court, and Cherie probably knows this better than me because she's studied it more recent than me, but in every state, if they were seeking the death penalty, you were entitled to appointed counsel. But Mr. Gideon down in Florida was accused of breaking into a pool hall and stealing coins out of the Coke machine or some vending machine. And because of his prior record, he was looking at years in prison. And he asked for the court to appoint him an attorney, and they said, you know, we don't appoint people attorneys in Florida for felonies unless we're seeking the death penalty. This isn't a death penalty case. Sorry, you don't get a lawyer. And then Gideon changed that, and Scooby's absolutely right. You're entitled to an appointed attorney on a felony case, and then they expanded that to misdemeanor cases. And so generally, anything that is more than a fine, you're entitled to appointment of counsel. But that's for the trial. And then you're also entitled to a lawyer, not in every state, but on a felony, any felony, which is you've been sentenced to serve more than a year in jail or probation for longer than a year. You're entitled to appointed counsel for an appeal, but the Supreme Court has not held that due process requires that the state appoint you an attorney for habeas corpus petitions or what Wisconsin calls a 97406. There's no due process right to a post-conviction attorney in that context, just on a direct appeal.
So it's really pretty narrow conditions, specific, in other words, where that would apply.
Yes. And so a plug for Amy, who's going to be with you, from what I understand, tomorrow at 5 o'clock on another case out of Indiana. Apparently, and maybe we can kind of clarify this, apparently in Indiana, they do appoint you a habeas corpus post-conviction attorney, because that's where the person that she's trying to help out, that's the stage of the process that she's in. She had a direct appeal, which was denied, and then they appointed an attorney, but because of the backlog, and I'm sure there's a huge backlog, it's going to be a while before they can get to it, and that's kind of where the process is. So if you're fortunate enough to be in a state that does appoint you an attorney for a 97406 habeas type petition, then you would be entitled to an effective attorney in that sense. But in Wisconsin and most states, you're not entitled to appointed counsel by the state. You're not, if it's a federal case, you're not entitled to appointment of counsel by the United States government.
Gotcha. Thank you. I think
And we've got a couple of questions in chat, Jack.
Go ahead.
Katie
go ahead.
Diddy's joined us. Hi, Katie. She says, are all these processes different in different states?
That was garbled on my end. Alice, could you say it one more time?
Oh, yep, sure. Are these processes that you're talking about, are they all different in different states?
This process, yes, that we're talking about is specific to Wisconsin, but the process is 90 to 95%. We can ask Cherie to comment on this also. They're 90 to 95% of them are identical, and there's a couple of twists. So procedural bar is pretty standard throughout the United States. We've talked about the reason why that is. There was habeas corpus reform even before the federal government did it as part of EDPA. So for example, in Wisconsin, they codified their 97406. It just used to be from case law. They codified it in statutes, the statute being 974.06. But let me see if Cherie has anything to add about that.
No, that's about, I don't know any more than what you've said. That's my understanding too.
Okay. And then there's a separate federal process. So if you're in state court and you're convicted and you exhaust your direct appeal, and then you've brought some post-conviction motions under a similar statute that Wisconsin has, 97406, and those are denied, you have 1 year from your last appeal to file a habeas corpus petition under section 2244 of the federal code. But you're going to be under EDPA, and that's the legislation that reformed federal habeas corpus. And, it's going to be very limited. And that's a much more different review for folks that stayed up and followed the appeal of Brendan closely, where that became evident. How it's a different process is when the Seventh Circuit, after the en banc hearing, the full Seventh Circuit, when they issued their opinion, they talked about things like finality and deference to the state courts. Those are things, deference is something that's unique to federal habeas. But Yes, what we're talking about is specifically Wisconsin, but these things are going to be very, very similar across the United States.
They just have they'll just have a different statute number for that state. That's what I've seen too. Of course, I'm not a lawyer, but different
Yeah.
statutes, but basically the same legal language.
Yes,
Yeah.
and then it may be and so in Wisconsin, we all know procedural bar comes from a case, that Naranjo case, right? In other states, rather than a case, it may be part of the statute that it may say, to bring it, part of your petition, you're required to show why it wasn't brought in an earlier motion, and there needs to be good cause or good reason, whatever their standard is. But between the statutes and the case law about their post-conviction process, they're going to be quite similar. And the main thing is that all of the states that did habeas corpus reform, what they were doing two things. They were making the doctrine of finality more concrete. And just because I'm explaining this, doesn't mean, I advocate or believe this needed to be done, but
Right.
you're going to see finality being mentioned a lot. And then the other thing they were trying to avoid is, and this did happen a lot, is successive habeas motions. And there was kind of strategy to that, especially in states with the death penalty. So they'd bring a habeas motion on certain things, and then they had other ones that they were going to time, when it got 30 days before the scheduled execution date. And they were motions that could have been brought much earlier, but for strategic reasons, they were brought later. But there was no prohibition to that. And you could do that in state court, you could do it in federal court, and you could file as many motions as you needed. And then what would happen is finally these appellate courts in the state and the federal courts would, just do one-liner denials. It would go to the U.S. Supreme Court, to the judge on duty for that circuit that they're in, and they would do a one-liner denial, and then the execution would go forward.
Yeah, EDPA, as we've discussed, for those that, just one quick thing, Alice, and I'll let you get to the other question. EDPA, from the reasonable guy, to me, it really slammed the window shut to a very narrow focus of what the federal court could do to overrule a state court.
Yeah, as I think everybody knows that's been following and saw MAM 2 and the excellent discussion that Drizzen and Nyrider did about EDPA, is you've got to show that the state court, the state trial court, state appellate court, clearly screwed up the law. That appellate courts don't screw up the law typically, even their interpretation of federal law. However, when Cherie and I do our presentation, there's a couple of cases where the Seventh Circuit has recently affirmed, in the last 4 or 5 years, has affirmed a federal district court reversing and ordering a new trial because the Wisconsin Court of Appeals messed up on the law. So it does happen, and but we'll go over those cases another time.
Sounds good. Alice, another question?
Mark has in chat. Hi, Mark. Nice to see you. He says, how can any court allow or deny forensic evidence not to be that of Stephen or Brendan, not to force an evidentiary hearing, i.e. the blood in the RAV?
Because the blood in the RAV is procedurally barred, and under their thing. So we'll cover Tuco's question. His question was, can Zellner and her firm ask that the Court of Appeals give her access to the RAV for testing? And the answer to that is no. The Court of Appeals is not a fact-finding court, and as a matter of fact, that's now what she can do is say it was error, it was wrong for the circuit court to deny me access to the RAV. And that's actually what happened in the big second 97406 motion. She had filed the motion for additional scientific testing. She had worked out by agreement the testing of some items and the review of some of the DNA swabs. Her DNA expert, if y'all remember, Ma'am 2 had a brown paper bag. He climbs in the back of the car with Kathleen, holds up the brown paper bag, says, yeah, this is what we got. We got, this. And then she was also given access to FL. The state transported it from Wisconsin to her trace evidence expert with the scanning electron microscope, and it was delivered there by one of the detectives in the case, I think Wiegert, but my memory is not as good as it was. And then her trace expert put it under an electron microscope and saw some red stuff, didn't see anything, looked like bone that you'd expect if it had been fired through a skull.
Right, it was wood, particle board.
And wood fragments. And then it was returned back to Wisconsin. Then in that process, and then she was in the process of negotiating with the state to get some additional samples from the RAV. And they were working that out. And if you followed those appeals, there was correspondence between Zellner and the attorneys for the state saying, hey, do we need to let the circuit court know that, we're doing more testing? And they responded back, no, we'll let them know when we filed the stipulation for these tests. We'll put in part of the stipulation, hey, we need to continue this and do more time. And then, as everybody will recall, while they were putting together that stipulation and getting ready to submit that, the circuit court issued its opinion denying Stephen's post-conviction 97406 motion, a second motion.
Yep.
She immediately said, hey, wait a minute, we were getting ready to do more testing, and she denied that, said, well, you should have let me know. Anyway, number of more motions, motions to remand to do rapid DNA testing on the bones, motion regarding the return of the bones in violation of the preservation statute. 6 motions, 5 of which went up on, well, all 6 of them went up on appeal. And unfortunately, the Court of Appeals sided with the state and said, yeah, she should have let the circuit court know that wanted to do more testing. And again, this goes back to the comment of the circuit court, I'm paraphrasing, was, you shouldn't have filed your motion, your 97406 motion, if you weren't done with testing. And then, as bad as that sounded and as unfair as that sounded, on top of it, the Court of Appeals quoted that and said, it's right, and we're not going to disturb, that is not an abuse of discretion, which is the standard. That's not an abuse of discretion, and we're not going to disturb it on appeal. And so, it's easy to kind of lose this stuff because these appeals are so complex and the issues are intertwined, and you've got standards for ineffective assistance of counsel, and you've got standards for Brady, and you've got new evidence that we're going to see in a minute what the 5-prong test for that is. And it's just easy to get lost in the fact that these issues were heard by the court and didn't go Stephen's way, unfortunately. Got to have some comment from the panel on that.
Well, I mean, I think that just personal opinion, from Jack, I think that, again, during that process, obviously, Kathleen made a mistake by dismissing Avery's pro se instead of just amending the damn thing and moving forward. That's another discussion. At the same time, I think that the conversations between her and Fallon were completely, I think he misled her. That's just following what Fallon has done in this case. And I'm not meaning that about everything, but about many things that I've just seen throughout between their correspondence. I don't know. I just get a really bad feeling because I know of the stuff that he pulled during the pre-trial and the trial, and even in Brendan's trial, and that's just my opinion. He's very
I
intelligent.
agree with you on that. That's where a lot of people learn for the first time what the doctrine of estoppel is, which Cherie will tell you, you can't take advantage of, can't use bad conduct, or you can't lead the other side into something, have them rely on that, and then try and yank it out from under them, except in Wisconsin.
There you go. Allison, any more questions? We good?
So I don't know if Tuco had any more, but that's the one he had put in the one in Discord asking that, and I hope I answered. Who was the last one? Was that Kaz?
Yeah, that was Mark. Yeah, the last question was Mark's question. Yeah.
Okay.
No, we're all good. We're all good.
Okay, so
I thought Tuco was also asking. Maybe I misunderstood him. Something about the 11-4 phone calls, but maybe I misunderstood what he was, because he said he wanted to ask another question, but maybe he'll come back and clarify that. So we can go ahead with your presentation. I've got the next page up, the newly discovered evidence.
Okay, so that's laid out there, and you'll see in a second why I wanted to repeat this, but So newly discovered evidence, and we can talk about this in later episodes or shows if we want to go into more detail, like the bloody blunt instrument, different things, but the evidence must have been discovered after trial. The moving party must not have been negligent in seeking to discover it. So with Sawinski, it was discovered after trial. He was reporting this to attorneys that weren't representing Stephen, and finally it got to Zellner that he had tried to report it, which apparently is confirmed in some manner with a phone call to the sheriff's office, must be material to the case. Evidence must not be merely cumulative. And what we talk about with that is it can't simply help the defense. It really must be new. So, for example, two witnesses at the time of the trial testified that Stephen was in Crivets on October 31st. And then a new witness comes forward that would have been better to know about, but they say, yeah, I know he was in Crivets because he and I went to the 4 Mile bar and we had beers up there, and here's the receipt for the beers, and we watched the Green Bay Packers game, and the score was 24-7, and we won. We beat Chicago, which is always great. Fuck the Bears, and but that would be cumulative. Then this fifth thing, and why it comes back to Stephen Avery, it must be reasonably probable that a different result would be reached at a new trial. Then I'm in that highlighted language right below that. The language in the fifth prong, reasonably probable, has a specific meaning in the law. A reasonable probability is a probability sufficient to, and you've heard Zellner say this hundreds of times in MAM 2, sufficient to undermine confidence in the verdict is the way she expresses it, but confidence in the outcome is the same thing. So what happened is, in this case involving DNA, a court of appeals messed up that definition. Unfortunately, this established meaning of reasonable probability was muddled in State v. Avery, Court of Appeals 1997, suggesting a defendant must prove a different outcome. These are subtle differences, but to go from presenting evidence that there would be a probability sufficient to undermine confidence in the outcome to being outcome determinative, suggesting a defendant must prove a different outcome, that's a huge leap for a defendant to overcome. That case right there, State v. Avery, 1997, that's Stephen Avery's case.
Wow.
Where they denied him a new trial based on the fingernail DNA of the victim. And we're gonna talk about that here. Next page, Jack. So I'm not going to go into this. I want to get into some of the stuff on witness credibility down below because it's much more entertaining than this law. State argues that reasonable probability means it's more likely than not a jury would have a reasonable doubt. So the state, they're citing this case, I pulled from another case, this is out of a brief. The state argues that reasonable probability means it's more likely than not a jury would have a reasonable doubt. So this is what the judge has to determine after an evidentiary hearing. Has to be a reasonable probability the jury would have found the defendant not guilty. In support of its argument, the state cites State v. Stephen Avery, 1997. Avery argues, now this is a different Avery. This is David Avery, and it's on a burglary case. What are the odds of that? Avery argues that the standard is whether the new evidence undermines the confidence in the verdict. State v. Armstrong, 2005, withdrawing language from Stephen Avery that a defendant must prove a reasonable probability of a different outcome. Armstrong is Jerry Buting's case that he did in conjunction with the Innocence Project, the main one, Barry Scheck's outfit in New York. He went up when he finally got his client exonerated, said, this standard is wrong. It's been wrong since 97. The Court of Appeals screwed it up then. And Jerry, in his book, says, Stephen was, finally vindicated on them using an improper standard on him back in 97. And so he would have been in prison, how long at that point? 85 to 97,
Yeah,
12 years.
Yep.
And then he served another 6.
Yes, that's correct.
Okay, so now we're going to get credibility of witnesses. So this is going to be good. Credibility of witnesses.
Sorry, Travis.
Go ahead. Go ahead.
I mean, what gets me is, right, I mean, we're going on about new evidence and things like that, right? So
Yep.
what happens, surely, if the prosecution withhold evidence and don't show it to the defense, and then after the trial and everything like that, the defense or that, and it is evident that the prosecution withheld this information which could have resulted in reasonable doubt or a completely different outcome of the case when it was being tried, surely that should class as new evidence, because that evidence wasn't available to the defense at the time because the prosecutors withheld that evidence. This is what annoys me, is because I've heard some people say, no, that doesn't matter. Well, that surely should matter because the defense couldn't get their hands on it.
And you're right. If you can show a Brady violation and that it meets the 3 criteria of Brady, it's an automatic new trial. And then, the problem is you got to show materiality and, the requirements that we've gone over under Brady. And then you saw, and you'll have to forgive me, I can't recall the specific issues that the Court of Appeals did judge on the merits that were Brady. I know there was at least 1 or 2, but in their analysis, and they had to review it de novo, which means anew, they had to look at it fresh. They said that Stephen didn't satisfy one of the 3 prongs under under Brady, and so it didn't qualify. But you're absolutely right. If you can meet all of the standards, and Wisconsin's it's more relaxed than under the federal wording of it, in that you don't have to show an ill motive of the prosecutor. All you need to show is that they didn't turn it over. The big prong is you got to show that it would matter. That it would be, that it's material, and that it would impact the outcome. And it's this undermine the confidence of the verdict. And unfortunately, the Court of Appeals said that. So it's mainly on the Veely CD, and unfortunately, there's a lot of stuff with that that kind of clouds the issue, because the CD was turned over, but not necessarily the report. That if they'd gone through the CD or DVD, they would have seen what the searches were. And there was a ton of back and forth on that. Unfortunately, it wasn't a fingerprint or a DNA profile or something that was clear cut. And that's why it's really difficult to understand. But Jack or Cherie, can you think of what the other, if there were any, that they decided on the merits?
Yeah, there was one
like
more
the
thing.
Veely's.
Yeah, there was the Veely CD under certain conditions, and there was some. God, I can't think of the other one, but there was one other thing.
Was it the Sawinski call? Maybe that came up at some point.
Yeah,
Or is
and
that-
that you're absolutely right.
Yeah.
Good call. That she hooked that in as Brady in this third 97406 motion, that should have been turned over, and that's one of her good arguments. What the circuit court said is, well, it's not material because it's 2 or 3 days after the date of the incident, and you can't show that that doesn't make that third party suspect guilty of the murder. All of those things. You're absolutely right, Cherie. Whereas the circuit court is just giving this the narrowest of definitions, that I'm hoping the Court of Appeals will say, you're just putting too narrow a focus on this. You need to they've set out enough that they should be able to explore it, and then you determine the credibility, and we'll take it from there.
Before we move on to the credibility of witnesses, you did bring it up, I did want to give a big plug to Jerry Buting's book, Illusions of Justice. It is an excellent, excellent book. He explains the Armstrong case. He talks about all kinds of things in his life, his near-death experiences. I guess near-death, he was really sick. And this was not long before the Avery case came along as well. It's a really good book. I highly recommend it.
Yeah, it is a great book. And the bit I loved the best in it, Jack, was the bit where he said that he was this close to punching cracks in the mouth in the judge's chambers. I was like,
Oh, yeah.
so much fly on the wall.
Yeah, Strang had to get between them.
And then Strang told him later, he goes, man, if I have one regret about this case is not letting you get one good punch in. Apparently
Buting got mad as hell at, some shenanigans that Kratz was pulling in the judge's chambers, and he had had enough.
Yeah. And a lot of that went back to the press conference that, Kratz was arguing, oh, well, you shouldn't be able to do this and this and that. And Jerry said my blood would just boil. And, after what he pulled with that press conference, he's trying to make this argument. Yeah. So.
Yeah, that was bad. All right. All yours, Travis.
Okay. So, this case is the Jordan case. It's also recent. And, the defendant filed a 974-06 motion, and he got 3 or 4 affidavits. We'll go through just real quick, but we'll see if anybody draws any parallels with any other cases we're interested in. But as we go through this, think about a couple of things, everybody. Okay, so why so we have the affidavit that they're going to talk about, but why is the person called in the evidentiary hearing? Think about that, and think about well, if you see credibility issues from the affidavits or the testimony in the evidentiary hearing, do you think Stephen should have got an evidentiary hearing with the 1 or the 2 witnesses that he submitted affidavits on? So the first person was Quincy Grant. And you with me, Jack, running our credibility of witnesses? In Quincy's affidavit, he claimed responsibility for the Robinson homicide and stated, don't go down to the next page yet, I'm willing to testify. And so the footnote in the affidavits, all signed 1 to 7 years after the shooting, the affiants are allegedly able to recall the make, model, and color of the cars involved in the shooting, the model of a gun they observed, and exacting details of conversations they had with newly discovered witnesses and actors in the shooting. And then the footnote below that, they're basically saying we're not going to determine whether he's.
That's number 7 footnote. Yeah, I'm with you. Travis.
Okay. So he says, I'm willing to testify in any proceeding on behalf of Joseph Jordan and at any of those hearings subjecting myself to penalties of perjury. However, while Quincy took the stand at Jordan's evidentiary hearing, he refused to testify, repeatedly invoking his Fifth Amendment. He wouldn't, you can skip down number 20 towards the bottom of page 5. Quincy's evidence does not establish any probability of a new result at trial. Quincy refused to testify even to the question of whether he in fact signed the affidavit attributed to him. And his invocation of the Fifth Amendment privilege is not evidence. His affidavit, even if admissible, which they didn't decide, creates no reasonable probability of a different result at trial. Next page, paragraph 21. Now this is Jason Honstein, and he submitted an affidavit support Jordan's contention he did not shoot Robinson because Jordan, was not in the car involved in the shooting. Honstein's affidavit purports to be a detailed firsthand account of who was in the car at the time of the shooting and of the shooting itself. However, at the hearing, Honstein testified that he had known Jordan all of his life, that I don't know who gave the affidavit to me, and that I was drunk when I signed it. The best part's in the highlight. I was intoxicated when I signed this thing. He testified that he signed the affidavit because I was just trying to help someone out. I've known him all my life, you know. Honstein confirmed that the handwritten signature was his, but the contents of the statement were, this was during the hearing, all bullshit. That's right out of the opinion. He denied being at the scene at the time of the shooting or knowing anything about the crime.
That's funny.
So paragraph 22, it just talks about why. So now we're at paragraph 23. So we got third affidavit, Dion Lee's evidence. In Lee's affidavit, he claimed to have met with Jones, the driver of the car from which Jordan fired the fatal shots immediately after the shooting. Lee claimed that he saw 3 men in the car, Jones and 2 men in the back seat, but that Jordan was not one of them. One of our affidavits in our case said the person in the vehicle they did not know, but they knew it wasn't Stephen Avery. At the hearing, Lee identified one of the 3 men in the car as Quincy and testified that he identified Quincy in a photo shown to him by police. Okay, so that's talking about some Brady stuff. Milwaukee Police Detective Jeremiah Jacks later testified that the individual in the photo who Lee identified as Quincy was actually Lonnie Davis, who had been in prison since 1997. So I'm now at paragraph 24. You with me, Jack?
Yep, I'm with you.
First, even assuming without deciding that Lee's evidence is truthful, the fact that Jordan was not in Jones' car at the time Lee met with Jones after the shooting does not mean that Jordan was not in the car at the time of the shooting. Does that sound familiar?
Well, yeah, there's definitely some parallel here.
Okay, so somebody, if they want to do some research in the next few days, can see if that case was cited. Jordan, I'll find out when that was here in a minute, or I don't know if Cherie has access to a keyboard, can type in Wisconsin v. Jordan. But that's where the circuit court came up with that argument. I guarantee it. I don't know if the state cited that and made the argument and she just rubber stamped it. I doubt she found it on her own, but who knows? I mean, do you see how close that is?
Yeah.
Furthermore, Lee's testimony in support of Jordan's new theory that Quincy was the shooter is undermined by Lee's faulty identification. Lee's testimony does not raise a reasonable probability that a trial would end in a different result. Now, some people may be saying, oh, so Court of Appeals is just going to rubber stamp it. Well, this is a little bit different. Remember what we talked about at the top? The standard for denying an evidentiary hearing is much different than having the evidentiary hearing and determining people don't have credibility. Right. So I'm hoping this helps elucidate, make clear this concept I've been trying to explain, that it's a different standard to deny an evidentiary hearing outright than it is to allow the evidentiary hearing and make conclusions after. Everybody with me so far? And we'll go to the next.
Absolutely.
Lonnie Davis's evidence. So you caught this, right? Going back up to 23 on the bottom of page 6, he said, I saw 3 men in a car. He identified Quincy in a photo shown to him by the police. Now, that would have been at the time of the investigation. And Milwaukee Police Detective Jacks later testified, which would have been at the evidentiary hearing, that who he identified as Quincy was Davis, meaning who had been in prison since 97. So his credibility was destroyed, but they didn't even go there. They did what the circuit court did in Stevens last 97406. They said, seeing this person after the shooting does not mean that Jordan was not in the car at the time of the shooting. All right, paragraph 25. You with me, Jack? Lonnie Davis's evidence.
Yep.
In his affidavit, Davis asserted that in January 07, Quincy admitted to Davis that he, Quincy, committed the homicide for which a jury convicted Jordan. So this Lonnie Davis, in his affidavit that was submitted, says in 07, Quincy admitted to Davis that Quincy was the real killer. On the stand, Davis testified consistent with his affidavit. However, Davis also admitting to telling Milwaukee police detectives, so this would be on cross-examination by the state, that the threat of perjury did not mean anything to him and that he was serving a sentence of 140 years. So they brought him in from prison. Even though Davis then testified that he was joking with the detectives, the records support the circuit court's conclusion that his affidavit and testimony were untruthful. In short, Davis's evidence does not establish any probability of a different result. Now at paragraph 26, bottom of page 7, Charlie Grant. Charlie claimed to know that Jordan was not the shooter because he, Charlie, was at the gas station at the time of the shooting and witnessed both of the cars involved in the shooting 30 seconds before shots were fired. Charlie claimed in his affidavit that the car Jones was driving contained 4 men, but that Jordan was not one of them. In the affidavit, Charlie does not mention ever personally speaking with Quincy about the shooting.
Now he's identifying before the shooting happened.
Right. Now, and we'll see what they say about that, but this is analogous.
Kind of off topic. Can I just ask kind of an off topic kind of question?
Absolutely.
Is this a case about, did he play for Wisconsin State, or was this a basketball player that we're talking about? Or no?
Certainly not Michael Jordan, but
No. Jordan Davis, or never mind. I must be thinking of the wrong thing. I'm so sorry. Go ahead.
No, it's okay. The last name is Jordan. Let me pull up the case site. It's State v. Joseph Jordan. It was decided June 25th of this year. Not recommended for publication. We know so far that it involved 2 vehicles with individuals that shot at each other.
Okay. All right. There was a similar, when you were saying Davis and Jordan, there was a Jordan Davis who played basketball for Wisconsin State who was in some sort of.
This is Joseph Jordan and his.
Right, I apologize for.
No, I believe he was convicted in 2011. So he's got a pretty quick 97406, but okay.
27.
Charlie Grant. He saw these things. Now we're at 27. Thank you. At the hearing, Charlie testified that sometime between April and June of 03, well, it's well before I don't know when they finally got him to trial. I just don't know that. Quincy told Charlie that Quincy, committed the homicide and not Jordan. Charlie never explains why he omitted this important information from his affidavit. That sound familiar to you guys?
It does.
Furthermore, at the hearing, Charlie claimed that he knew Jordan was not the shooter based on his conversation with Quincy, and not because he allegedly personally observed the parties involved in the shooting just moments before it occurred. So that must have been brought out during cross-examination. He also claimed at the hearing that the car he observed Jones driving at the gas station moments before the shooting had 3 people in it rather than 4, that not all of them were male. Number 28, Charlie's contradictory testimony and failure to explain why he omitted Quincy's confession from his affidavit support the circuit court's conclusion that his testimony was untruthful. The evidence would not result in a new outcome at trial. So he lost. I just thought we'd use that because it's dead bang, on point of, one, it demonstrates the difference between a judge denying an evidentiary hearing and a judge that's granted an evidentiary hearing and is asked to look at evidence. Now, of course, we don't know, being foul play, wrecking crew people, you all are insane. You all would be doing requests for the transcripts of the evidentiary hearing, and which is good. And you would say, we want the affidavits. You don't want a summary by the court. And you would look in it and you would make your own determination, your own research. What does Silkman say? Don't take our word for it. Read it yourself. Everybody on the panel agree with that?
Absolutely. Go do your own research. That's the key.
100%.
I think that we our interest is in the truth, and wherever that truth leads and wherever it goes, we're going to follow it, good, bad, or indifferent. We feel that what's happened in the case certainly is at minimum deserves a new trial, and certainly a release of Brendan. We don't think he's involved at all, but certainly a new trial. Get this evidence, get everything in front of a jury, everything that's really relevant, which I think, personally, I think that the jury was screwed. I think Judge Willis was screwed. And they weren't allowed to see everything that was relevant. And I think that's at the end of the day, that's what's important. Do your own research, absolutely. I'm not here to change your mind. I'm just here to present what I feel is more of the truth than what we ever saw at trial.
Right. So we've learned over the years with the appeals and whatnot that I don't want to say you can't trust. Everybody's writing from a bias or an angle in the criminal justice system, or whether it's a civil or a criminal case. So the attorneys for the parties, they're writing from their angle, and they're saying cases say certain things from their point of view. And then the court, they're writing from an angle to justify their decision, right? So it's not that you can't trust, but if you really want to know what's going on and you really want to know for yourself, that's why you need to read the transcripts. That's why you need to read the actual affidavits to see what's going on. So 2 of these people, one was called and then pleads the 5th. Why on earth would the defense attorney even call him to the evidentiary hearing? Anyone have any ideas? A bad defense attorney? Something else? Anyone have any thoughts?
I'll let Cherie go because
It does, honestly, it doesn't make sense to me, but maybe there's a twist I'm not aware of.
So, this defendant, before trial, had hired and fired 3 or 4 lawyers and then insisted that he represent himself. That was denied, and he had an attorney for the trial. Then before the evidentiary hearing, he insisted that he be allowed to represent himself in the evidentiary hearing, which the court denied. It says it's going to be too chaotic, and I left that part out intentionally. So that tells me that the attorney was telling Jordan, look, we don't want these guys. This is going to blow up in your face, and it's going to be bad. And the client said, no, I insist. Look, I've talked to this guy, and he's not going to help us. No, when he gets on the stand and he sees me, he's my homie, and I don't know if he said that artistic license, and he's going to do me a solid. And then he gets up there and says, no, it's all bullshit. It's
that's crazy.
And so Cherie, even though she's doing a different type of law, early in her career, she could tell you this is kind of the stuff defense attorneys face. And, our ethical obligation is if we put somebody up on the stand that we know is going to lie. That's different. We have an ethical obligation to report that. And there's a number of ways to do that without violating attorney-client privilege and without messing up your client too bad. But, they insist that, no, I want you to call this person, and, you're pretty much under an obligation to call that person unless the rules of ethics prevent you from calling that person. And Cherie can tell you, you just, sometimes you can't talk any sense into a client. And even more difficult sense into a client who's been wrongfully convicted and sitting in prison for years. But I think, there's probably, if you looked at the transcript and had more of the puzzle, there'd be a backstory that kind of gets filled in by knowing that Jordan wanted to fire his attorney at the evidentiary hearing and wanted to represent himself, and the circuit court said no, it'd just be too chaotic with this guy. So
That would be crazy, having somebody get up on the stand and say it's all bullshit. I can't even imagine.
Yeah. And, I think obviously these affidavits, we saw one that they described, they put SIC showing, was inartfully worded, wasn't written by a paralegal or an attorney or even a private investigator. Jordan or, Jordan's family probably helped him with those affidavits and, didn't go through the normal process. Again, I want to emphasize this is a different situation than if a defense attorney knows somebody is going to lie when they get on the stand. And
Right.
none of these situations apply to that. It's different. It's what they're going to do is say, I lied in my affidavit, or I refuse to testify. I'm going to plead the fifth.
Plead the fifth, yeah.
That's a whole different thing. So,
But at least this judge allowed the hearing to happen, and then the decisions were made based on X, Y, and Z, what was said, and so forth by the witnesses. Yeah.
mhm. So, and I don't have the briefs. I don't know what the state argued in terms of whether, I don't know if they may not even have argued against allowing the evidentiary hearing. But, whole different deal. They went in with this flimsy story, and one admitted to that it was bullshit. He was drunk. The other pled the fifth, wouldn't even testify that he signed the affidavit. So it's of no evidence. And then the ones that he did hear, the judge did hear, I don't know if it was male or female, judge said, they're not credible. And so what the Court of Appeals is looking at is, were these credibility determinations, were they clear error? And you saw what the court said, that and one of these, he identified a guy who was in prison at the time. The other one, and then I thought it was highly interesting that the exact same argument about the third-party suspect seen pushing the RAV down the road 2-3 days after the date of the murder weren't material. And that, we saw, another argument from another witness that were a change. All of a sudden, now he's got confession in his second affidavit that was left out of the first. But very astute point, Jack. At least this person got an evidentiary hearing, and those affidavits and the testimony of those individuals could be tested under the rigors of cross-examination. So there you have it. And I'd be happy to answer any more questions, or if you guys want to switch to a different topic, be my guest. Maybe we should just check if there are any more questions that popped up, and I hope this has been informative.
Certainly has for me, Travis. I appreciate you going through and doing this research and showing specifically that whoever this judge was and whatever circumstances were in this other case, at least they allowed the hearing to happen and then made their decision from that. I will also say that Cherie has pulled up State v. Jordan, and I've popped just the top of the first page up on screen. I'm certainly not going to go through it, but we have it available. Anybody that may want it can let me know or let Cherie know, and we can hand you off this PDF if you have interest in reading it.
I'm not sure if that's the one that he's talking about, though. I think it's the same defendant, but it's not from June of this year, so it might not be the right one yet. It doesn't sound like it's the right one.
Yeah, that was the same one I had pulled up, and that's why I got confused earlier. So I couldn't find
Joseph
it
J.
either.
Jordan. This is Joseph J. Jordan. I don't know. We can check that out. But anyway.
Let's see. This is District 1, decided 6/25/13, not recommended for publication.
I'm looking here, Travis. Joseph Jordan appeals pro se from the Circuit Court's order denying Wisconsin Statute 97406, 2011-2012 post-conviction motion for a new trial, and the subsequent motion for reconsideration. For reasons which follow, we affirm. All references to the Wisconsin statutes are to the 2011-12 version. Then it goes into the background, which I'm not going to read. It is a July 2002 case.
Maybe the same one, and then I have that confused with a case where they, one of the issues was post-conviction counsel. I may have just confused those because I've gone through about 15 cases, and so
this does talk about a guy named Robinson and a gun deal. So I think
that's it.
It's the same case.
Yeah.
Okay. Alice or Cherie, Rhonda, do you see any questions that we haven't gotten to?
No, everybody's thinking Travis, of course, but I don't really see any questions unless Alice or Cherie has seen them.
Yeah, I've been trying to kind of follow in was Travis was talking. I was looking back, but I didn't really see any questions. You know, I think I think the big thing, you know, certainly on everyone's mind, is certainly moving forward in Avery's case. If, and I should probably just say when Zellner files for an extension, I can't imagine she's done that before, you know, several times because it is a lot. I don't disagree. And certainly when that potentially, you know, things could happen in the Court of Appeals. My guess is minimum 6 months, but it could be longer. And it could be shorter too. That's just a guess. Minimum 6 months.
Yeah, so I went back and looked at, it's kind of hard to tell from the second post-conviction motion, but once everything finally did get filed, and you factored in the delays because of motions to remand and whatnot, the process from that the court denied the motion for post-conviction relief, and as part of that denied any evidentiary hearings, to the time the Court of Appeals issued a decision was right at about 1 year. And again, it was much, much longer, but I factored out the motions to remand and the delay because of that. And that seems to be in that particular division what they're running. And so, you know, I figure about a year. Next September, October, we'll have a decision on it, or it could be much earlier. And
yeah, that's kind of what I figured too, Travis. It just, you know, with back and forth and extensions and so forth and so on, that's kind of what I figured as well.
Yeah, you have the right slip opinion. Brennan Justice, paragraph 1, Joseph Jordan appeals pro se. He appeals pro se, and then in that decision, there's some discussion. It gets really convoluted about whether he had the right to proceed pro se, and it just really didn't fit in for purposes of what we're talking about, because Stephen thankfully never requested that he be allowed to proceed. That's on page 14 of that slip opinion, Roman numeral 3, it's paragraph 35. Complains the circuit court erroneously denied him a meaningful opportunity, refused him, allow him to represent himself. So, I did have the right case, and that kind of fills in the gap on why those witnesses actually got called during the evidentiary hearing.
You know, Travis, I do kind of have a question, and you've probably answered it, but I'll ask, and you can answer this briefly, or however you want to answer it. But am I remembering correctly that when, a defense attorney, just say Zellner, provides these affidavits and so forth to the circuit court, unless there's something really out there egregious, the circuit court judge has to take it as truth or something?
Yes.
Okay, that's what I thought.
They can't dig behind the credibility of it. They can't dig behind it and shouldn't say, oh, well, there's a co-defendant in another case who can confess to the crimes, and that's been ruled a legally valid confession. That should not have entered into it whatsoever.
You're talking about when she brought Brendan into the whole equation.
Right. And so essentially they're accepted as true because you're not allowed to get into the credibility at all. Unless the record is so clear that you're not entitled to an evidentiary hearing, you should get the hearing. And that's why the standard of review, that determination is reviewed de novo. In other words, the Court of Appeals is not going to trust the circuit court made the right decision like they do with credibility. They're just not going to do that. They're going to look at it on their own to see if that's the case. And we're hopeful that the Court of Appeals is going to say, look, what you're requiring, circuit court judge, is just beyond the pale. No one could ever satisfy the level of what they're trying to show. And
yeah, she set the bar so high. I'm not a lawyer, but I don't see anyone could reach it.
Well, you take all of the things that she pointed out. No one saw the third party suspect with the key. No one saw this. No one, there's no testimony about that. You take all of those things together, and I only read one, maybe two, when I was going through it with Kelly, when she was helping me put the stuff together. I'm going, I have some optimism here because what she's requiring is just such a high bar, as you say, that there's just no way, as a practical matter, you'd be able to go out and show this stuff because you have no subpoena power. You can't subpoena anybody. You can't take their deposition. You can't force them to give you an affidavit if they don't want to give you an affidavit. You can send an investigator out and try and get that, but if they say, no, we're not going to give it to you, we're not going to tell you for example, the funeral home says, I'm sorry, our policy is, we're not going to tell you what we received or if we even received it or if they're even a client of the Whiting Funeral Home, I believe is the name of it.
Yep.
You have no mechanism in post-conviction, you have no mechanism to demand that they give you the RAV2 test. You have no mechanism other than filing a motion in court for additional testing, which she did. So there's a process for it, but outside of that process, what the circuit court was expecting or commenting on about what wasn't provided or what wasn't addressed, or we don't have evidence of this, that Avery fails to blah blah blah. Well, you can't get it. There's no way to get it.
Right.
Which is why I suspect Kathleen tweeted or X'd, whatever the hell it is these days, that
Exeter.
she's really glad she's back in the Court of Appeals.
Yeah. Scooby did have a question, but I guess because she's been away and she hasn't been participating in the case. She wants you to explain as best she can, basically where the case is. I guess starting with this third 97406. Just
okay, yeah, we can do that real succinctly. So
sure.
There were 6 motions that went up on appeal as part of the second 97406 motion, and that was the motion she filed after the motion for additional testing. That was part of MAM 2, and the stuff about the bones came into it, and then at the very, very tail end, she filed a motion to remand because she located this witness, Sawinski. Sawinski had come forward and provided the information. The Court of Appeals said, no, we're too far along on our decision. You can bring that in a separate motion. And then they proceeded to decide the other 5 motions, essentially denying Stephen an evidentiary hearing or a new trial. Then in Wisconsin, like most places, you can appeal that decision to the Wisconsin Supreme Court, but it's a discretionary appeal. You file an appeal, then the court looks at it, determines whether there's issues they think are important enough to be decided. They denied review, so there was really no appeal, and then that basically was the end of that second 97406 motion. Then Kathleen Zellner took the Court of Appeals up on its invitation and filed what we're referring to as the third 97406 motion. How long did that drag out, guys, from the time she first filed it to the decision last month? Was it 6, 8 months?
Well, she filed it at the end of January this year. So yeah, it's basically seven months, I guess.
And she denied Stephen's request for an evidentiary hearing regarding witnesses who provided affidavits, which is just a written statement under oath and penalty of perjury, that they saw a third-party suspect, not Stephen Avery, pushing the RAV down the road a day or two, or one, 2, 3 is how they say it in Wisconsin, days after the murder, and that they wanted an evidentiary hearing to explore that, to show that this is information that should have been turned over to Stephen's defense attorneys under Brady, and that they would have been able to use that information to establish a Denny suspect. So she said, I'm not even going to give you an evidentiary hearing on it, and denied the motion. So she had the right to appeal that to the Court of Appeals in Wisconsin. for that area. And she filed a notice of appeal. There's a couple of days that get triggered from that. One is there's a certain amount of time for a court reporter to furnish a transcript to the Court of Appeals if there was a hearing. There was not, so that deadline doesn't apply. The other deadline is for the clerk to send the record up to the Court of Appeals, and there's a deadline for that, and believe that's sometime in October, and then she has 40 days to file her opening brief unless she requests an extension, and that's where we are. We are waiting for Stephen Avery's attorneys to file their brief on this current appeal. Did I leave anything out, Shuri?
I think you summarized it really well. I mean, a little more detail than that certainly is the open records request that revealed, 22 more CDs, DVDs last year, which the Sowinski call was revealed that had been denied for years and years. And then, of course, that along with that, we had the Sowinski affidavit, his ex-fiance, I guess at the time in 2005, her affidavit. And then we got after all that, we got the Baresh affidavit. I think that's all I can recall at the moment.
Yeah, a good point. Thanks for filling that in, because I wouldn't even venture to say all the stuff. So that's what's going on in terms of the legal case and the appeals. And then in terms of what foul play has been doing, I don't know, probably 100 videos. If you haven't been following the case last 2-3 years, there's a lot of videos. I think this is number 161 of open mic. That's just on that, and y'all are doing a number of things on that end in terms of research, but in getting significant amount of information that nobody has ever had. Nobody. The dispatch calls, radio calls, phone calls. So I'm glad you're commenting on that, because there's a tremendous amount that's been going on in terms of what the foul play team's been doing.
Yeah, I mean, that process continues, and it's become really, really difficult for open records requests, specifically from the DOJ and Calumet County. They are being very, I don't know what the right word is, but delay. I mean, to the point I can't even get hardly a response from Calumet County at all. There's actually records that, no one's ever seen or heard that they don't want to release. Specifically one in Brendan's case that I've been trying to get for 13 months now. And there's absolutely, as far as I know, no legal reason for that record not to be released. None. There's no appeals. There hasn't been for years. There's nothing been filed in Brendan's case at all. And it's really frustrating on that end, but we're fixing to take a different track on that. There's also jail calls that we haven't been able to get. Specifically, there's 5 or 6 calls between October 28th and November 6th between Stephen and Jody Stokowski. They won't let me have. There are phone calls from Jody from December 10, 2005 until February 17, 2006. I can't get, or haven't yet. I'm still working on it. I did get a number of calls, though, as everyone remembers, between Jody and Chuck from February 18th, I think it is, 2006, until she was released on March 6th. There were a number of calls. I can't remember the number now, 40 or 50. It was quite a few. But for some reason, these other calls have been withheld. And I really don't understand it, because at the time I requested them, there was nothing going on in the case, nothing legal at all. So that process continues, Travis, and it's going to continue. And for me personally, I know that a lot of this material we've covered, but there's new people that come along all the time, and they want to know more. At the same time, I think it's important, just from a case standpoint, that we continue to talk about it and keep it, at least as much as we can, in the public eye. Now, I know not everyone agrees with that, and I understand. At the same time, there is such a massive amount of information in this case, and Brendan's case. It's really difficult for one or two or even three people. I mean, it really takes a village for me to cover all the material in this case. But I think it's important that we keep it alive as much as we can.
Oh, you have to keep talking about it. There's no question. So that part of it is very, very important to keep talking about it, because, the other side, they just kind of go away. They move on to the next deal, and
Yep.
Because at least for people that saw this, and when they saw it and said, well, neither of these gentlemen, or one or the other, didn't get a fair trial. That's a much more motivating force than trying to solve a whodunit that a lot of people in the true crime genre, that I think that's why they're attracted to it. And, that's why I am. The books I've read in the true crime format and whatnot. But, when you bridge over to where, you're investing the time to read the documents and do your own research, make your own conclusions. I think the motivation for that is, did these gentlemen receive a fair trial, or didn't they? And, and as a practical matter, it's the lawyers that have to do that in the court process. Every once in a while, a private investigator or a family member who's got some acumen and knows how to maneuver can get information and maybe do some record requests from the police, and the police turn over stuff that they didn't realize was withheld from the defense. And because those people moved on and new people came in, and it's a 10 or 15-year-old case. I've seen that happen, but it's and so what are we left with? It's smart, educated. When I mean educated, I'm not talking necessarily degrees, but you get a variety of people like Dr. Silkman, Scooby, that know the DNA side of things, which, I don't. And I'm a lawyer, but I went to law school to avoid math and science. So then you get people that, heck, maybe they've had encounters with law enforcement or, a background. But, you get a lot of different backgrounds looking at things from different sides, and you talk about it, but reasonable, educated people, not nuts, not a cult, are looking at this thing and it's causing them concerns. And they look at it and they see things that undermine the confidence in the verdict, which is the standard that a judge would be looking at. So
Yeah,
it's important to talk about it and look at, and some of the stuff which isn't associated with foul play, is heated debates and drama and intrigue, and I think that's more on the entertainment side. But that's, foul play walks a pretty narrow line on that and talks, okay, well, yeah, you can throw out a theory, but back it up. And then as long as you're respectful to each other, as Dr. Silkman would say, and you, Jack, as long as you're respectful, you can comment about what you think is somebody's theory, and, but talking about these things and what the concerns are very, very important.
Yeah, I think way back, actually, I know way back in the day, and I'm talking about, 2016, where we really didn't know jack shit, pardon my French, but we didn't. We really didn't. Really, all we had to go on was, what we saw in Making a Murderer. Some newspaper articles we were able to pull up. There were actually more news reports. A lot of them got yanked, but there were some news reports that were from these various different stations back at the time that we were able to get. But any real documentation, that didn't really happen for a couple of months until we raised money, did the crowdsourcing. Actually, we did 2 crowdsourced fundraisers to get documents for Stephen and Brendan's cases, and we really started going through, and then that bloomed into others doing even more requests on their own, or a few people getting together and chipping in, passing the hat around to get various documentation. And come to find out that what we really saw, and we got a pretty good glimpse in Making a Murderer. Certainly it had its own biases, but we got a really good glimpse through the documentation, the dispatch calls, the jail calls, all this other information that we really only got just a little trickle of in MAM that was not presented at trial, and the jury didn't get to hear it. They didn't get to see it. It was, for whatever reason, I blame Ken Kratz, but that's me. But he was accompanied by 2 other special prosecutors, one of them being from the AAG's office, and that leads credence. And he was allowed this awful press conference he did on March 2nd, 2006, completely awful, and I think he should have been sanctioned for it. It was allowed. Judge Willis didn't bat an eye. Anyway, I'm not going to get off all that. It made me question, and I don't really have I've watched true crime for years, read about it, but I never really got heavily involved in any one single case until this case. I don't know Avery. I don't know Dassey. I'll talk to Barb from time to time. I really don't know. This could be anyone person. It didn't have to be Stephen Avery or Brendan Dassey. What I see was really just throwing due process completely out the window, or 98% of it out the window. Just from what I've learned in the case over the last, almost 8 years now. I never thought I would get involved in, something like this. It was never my intention. I just wanted to do my thing from, my little corner of the world, digital world. Find out what I could, give that to people that were interested as well, let them do their own research. Never thought I'd be doing anything like this. It was never a goal. I don't if I could just be a number, number 008, that would be fine with me. I'm not looking for bright lights and popularity or any kind of ego thing. It's not it for me. It never has been. And I actually have, talked about that kind of thing being a problem within the community. And it has been. We have to be honest about that. So it's never been about that for me. It's about these folks doing the right thing, whatever that is. If somebody showed me something right now that said Stephen did it, they had actual proof that's verifiable and not questionable, like we have in our face, okay, do it. But I'm not seeing it. I just haven't. Or Brendan, for sure.
Yeah, it's so I had a bunch of people calling me after MAM 1, which came out in December, like in the
December 2019.
holiday break area. And so, people were able to binge watch it because they were off work. And anyway, so I started getting calls from friends, it's dentists, doctors, you've been watching this, how the hell? I said, yeah, I did watch it. It's, fascinating. And I said, let me take a look. And then, so whatever appeals were up there, I don't think started really looking into it, but I looked at it first and there was nothing. I said, you really can't comment. We got to have the trial transcript, and then whoever put the money together to get the trial transcript and whatnot, but that's the first thing. You've got to have the trial transcript.
And the pretrial, all the motions, because that leads up to the trial.
Yep. And so, by the time MAM 2 and Zellner had filed her motions and whatnot, and I've said this a number of times, when she filed the second 97406 motion, most of the people, commenting on it, they were kind of going through how you would go through, and you're kind of going through the motion. They'd either summarize it and go through chronologically, page by page. I started with the exhibits because I wanted to see what the experts were going to say. I wanted to see what experts she ended up with, and which was way different than what the experts she was talking about trying to get in the motion for additional testing. And Dr. Silkman's talked about, the stuff she was trying to do on aging the blood and so on and so forth. And, and it took a drastic turn. This was before MAM 2, and so looking at that, but by that time, people were getting this stuff and they were posting these motions, because Wisconsin didn't have the greatest clerk system. In Texas, you can pretty much, anybody can get any documents, and you just download them. They're all public. In Wisconsin, you got to pay and have them mailed. Of course, federal, everything's available through PACER system, but at a minimum, and I don't care what it is. The West Memphis 3, there were 3 full-length documentaries made on HBO, and
Paradise Lost.
But eventually, and this is back in the days, way before Netflix. I mean, the internet was new, and there just wasn't the stuff. There was no social media and whatnot, but they did create a website that had all of the documents. And again, without those transcripts and all of that, you can't do what you all do on foul play, being you dig into what you're interested in, and you make up your own mind. You're not listening to, I'll call them a content creator, whether they're on YouTube, whether they're on
Facebook,
an internet news service, for lack of a better word, run by political talking head. You're not going by what somebody's telling you about a particular case, whether it's a documentarian. You're guiding each other on, okay, well, if you're interested in why this or why that, this is where to start, or check out our library, and this is where you want to look in the library. That's what I've seen, especially the way Discord works. And some people may be totally satisfied, and it's absolutely fine. They trust the credibility of people on your panel, or whoever may be talking about certain things. They don't want to, don't have the time to digest everything that some of the other people do, and they trust. Plus the way you all interact and exchange respectfully. I think there could be this individual may had the opportunity to plant bones, and I've explored that in depth, what supports that, but it gets tossed out there, and then people what do you think? And if they're respectful, there's discussion about, well, this is my problem with that, and it's different. It's a completely different vehicle than entertainment, which is as well done as the documentaries were done in West Memphis 3, as well done as the documentary was done on MAM 1 and 2. That stuff's entertainment. And
it's a for-profit. These are for-profit people.
It's show business.
That's right.
And we saw that. It was very enlightening to me that when Netflix decided to back the project with the producers, and how involved they got, and it was down to a selection of music to bring you up to a cliffhanger, and where maybe we should divide this into 2 episodes so we can end on this. Because of that, how many of your people in chat or on your panel, you couldn't just eat one Lay's potato chip. You couldn't watch one episode. I mean, you stayed up till 4 a.m. Before you just finally couldn't do any more and had to go to work 2 hours later. I mean, stuff doesn't happen by chance. And so, we all know about the popularity and whatnot. But then it's what happens after that. And we heard what, Beating talks about it in his book. Strang talks about it in MAM 1. Well, what do? Well, you talk about it. And so the MAM 1 provided a vehicle. People could talk about, how many times have you seen over the last many, many years, and talking about this with other people, and I say talk, communicate online, in Discord or in chat or whatever it may be that, yeah, there's a case here where yada, yada, yada. And then all of a sudden, other series, I don't think they piggyback, but I don't know if people remember those Innocent series on Netflix where they showed the Philadelphia cases. And my friend Patricia Cummings became the conviction, integrity, crime head of the Philadelphia prosecutor's office after having that position in Dallas, and getting cases overturned that were very questionable in a streamlined fashion. All of a sudden they're seeing these things and they're being educated. And so now we're seeing polls. I think I just saw a poll or a petition or one of those online things. Wisconsin needs a conviction integrity unit. I'd venture to say, 99.9% of the people, that aren't in the legal community, never heard of that before. But now, you've got people aware of it and non-attorneys asking for that, and they're aware of Innocence projects. They're aware of what DNA can show, and as Dr. Silkman mentioned in a recent episode, and I think I saw Scooby comment on this recently in Discord about that. I'm not going to use the word weaponized, but DNA has been a great thing in exonerating people, but it can also be misused or misunderstood to where, nothing's going to be worse than having something that can exonerate somebody, especially somebody that's on death row. But, there's things with DNA that you just, you really need to be careful about. And then there was documentary about this odontologist that was working out of a strip mall, and I mean, this guy's a dentist, and he was all proud of his testimony, and it was just all junk and garbage.
That was Dr. Michael West. That
Yeah.
guy. Oh my God, that guy. Yeah, you talked about some of these other documentaries that have come out. There's I think it was one of them was, I know one of them was for sure How to Fix a Drug Scandal. That one was really eye-opening.
Yeah. Yeah.
And
Now, the thing about that, I saw that coming on, and, I told Richard, Eric Jose, I said, you've got to watch those, and said it's really hard to pick out. But it's in there if you look out for it. So I'm just going to tell you right ahead, the spoiler, you're going to see where they talk about that in Massachusetts, one of these labs was under a non-law enforcement governmental agency. I can't remember what it was. And then to save money and costs and so on and so forth, that lab got put under the staties, which if you're from Massachusetts, is the state police. And so now it was under law enforcement. There was a big push to get, a certain number of tests per day or per person. And so it fed into the psyche of one of the technicians. She was the number one producer, and this is the one that didn't have the drug problem. And with her family, their culture, education, doing well in your job, And, and then people started looking at it and going, wait a minute, she's doing triple the amount of tests as anyone else in the office. But they didn't even catch it internally. They were just so happy. All she does is, eat, sleep, work on, her test. And then somebody else caught it. I think it was a defense attorney who got discovery and said, we want her.
Logs.
Yeah. And then that attorney worked with somebody else who got discovery in a case. And they're like, what do we know? And this network of defense attorneys are like, man, something's not right here. And then only then did the lab director give a shit that what she was, her work product, was physically impossible. That's when it became a problem. And, there's been a number like that. And somebody mentioned, we see parallels with the OJ case and Discord. Absolutely, the blood and the EDTA, but access to blood. That's why the defense was what it was at trial. They now had a viable source of initially blood in the RAV, and it's very, very difficult to go in with a planning defense. They talked about that in AM1, the book, Buting's book you commended to people. He goes into that, it's difficult, but the platform you all have, the way you do it, and what you encourage people to do, their own research, I think does a tremendous amount of good, and I think it's very important that conversation continue to happen the way you do it. I do think you run into, content creators, for creating content, it furthers the conversation, but the ultimate goal is completely different. It's, they're trying to, go ahead, I'm done.
Well, no, I mean, you certainly want to talk about things people have interest in, and that's, can be a challenge, another part of this whole thing, well, there's actually two things I'll comment on. I'll let you talk, or anybody else that wants to talk. There's two more things in this case that, one of them is specific that's tied to it, and it always seems to get kind of left at the back of the bus, so to speak, and that's the depositions that precluded Teresa going missing. It's such an important factor, in my opinion. This is just Jack's opinion, and the actions surrounding Gregory Allen and what happened, basically the month that the deposition started in 2005, and that's when this cold case, got looked into deeply. They took Gregory Allen's DNA in June of 2005 when he was in prison in Wisconsin, when they really, found that their initial DNA thing was a match. So they wanted a fresh sample, went and got it in June. It was a match to this 1991 cold case. Then he beat the hell out of this woman and assaulted her. And then a couple months later, in September of 2005, this judge signs an arrest warrant for Gregory Allen. To me, that had to make the Raptors shake at the highest levels in Wisconsin. And heck, I mean, I'm not a lawyer. That's just what I think. That had to send tremors through the hallways. Because this cold case, was never talked about in the media or anywhere else. Never talked about. And then they delayed for whatever reason, I'm not, again, not a lawyer, I can't explain that entire process, that warrant wasn't served on Gregory Allen for 27 months until after both trials were done. I found that really suspect. That's my opinion. It was never mentioned in the media. I found that suspect too. But cold cases are talked about all the time, and this one's not at all. So,
Yeah, that should raise the hair on the back of your neck. But I'd love to hear Cherie what her thoughts are, and Rhonda.
absolutely. Cherie's muted. She must be doing something. Rhonda!
She
Rhonda
fell asleep.
she may have stepped away to eat. Oh, there she is.
So- Sorry, I stepped away for a second, but I've been listening. You want to hear what I think about what? Because my mind is just
I
full
only
of.
covered 27 topics and a half. About the format of foul play in conjunction with the library and the materials available, and having all of those things so that you can explore things on your own if you want to, or if you feel comfortable hearing people like you and Jack and Dr. Silkman and others talk about the case, and you trust what they've dug into, and you trust how they summarize documents. But either way, and then the ability to go to a platform like Discord facilitates a healthy and productive conversation about cases like this. That's kind of what we were talking about.
Yeah.
Right. Well, I think that what has been put together in foul play is in epic proportions, a full library, like you said, on the site, the website, of everything that we know to this minute. We are sharing with everybody who has the ability to have an open mind and look at the evidence. And I find so often that people are just, what do they call them? The keyboard warriors. Oh, he's guilty. They did it. They blah, 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 blah. And when I say, well, bring me your, I have an open mind. Share with me what you have that proves that. And they can't do it. And so I suggest to them, we have this vast library of information on our website that is free for you to use with your open mind to go and get the information. We're giving you the information that has been painstakingly and at great cost, financial cost, so that you can research it yourself and get to your own conclusions. People don't want to do that. They want to, it is just easier for people to say, nope, guilty. Nope, I don't have to show you any evidence. You don't have to show me any evidence. But don't be writing checks that your fucking ass can't cash then. Because you can't just come to a topic like this and just say, I know they're guilty. Well, what about this? Well, what about the games that all the guilters play? Well, foul play has given every single bit of that to you, every bit that we could get our hands on, that was turned over to us via FOIAs, and admittedly, and Jack has said it too. We've all said it. We're not able to get our hands on everything that's really there, obviously. I mean, we're seeing that already through, I think, glimpses of that through CAM. So I am very proud of the format. I am very proud of us as a team. Just like any other organization or team, or, there are differences of opinions, but we hash that out. We work that out. It's never arguments or anything like that. It's just, well, I don't understand this. It doesn't make sense to me. This is how I see it. Explain it to me in a way that maybe I can understand or draw. I'm really bad. I'm a visual person and I need pictures. I hate that about myself, but I need the pictures. I need I need to be able to see.
Visual's always better, sis.
I am just, yeah, I'm just very visual like that, and I need to see it. I need to be able to read it, and if it takes me 15 times reading it, I need to be able to do that myself to be able to make it make sense, or see if it even does make sense. And I'm very proud of what Foul Play has put together on the website alone and just giving to people for free. But the people who really want to know will go to the website. If they really have that open mind and they wanted to find truth and evidence and facts and documents and transcripts. And I agree with what you guys were saying earlier. Transcripts and pretrial or preliminary hearing transcripts are very, very important. And I don't want to say the key or the biggest part of, but without that, trying to bring all the other stuff in is really, it's helpful and it gives you a place to go, but it doesn't give you a process and an outcome without actually reading those transcripts. And that's become evident with us as a team in Foul Play, reading through all of the preliminary or the pretrial motions and hearings and all the transcripts. And it doesn't make sense to me that somebody who claims they know somebody's guilty can just say, nope, I know they're guilty by the way he acts, by the way he looks, by prior, what do they call that? Prior bad past or whatever. You can't rely on that. And if you really want to know if what we as a team are saying is true, or you're not sure, but if you're really truthful about that and you really have an interest in finding the truth or learning the truth, then go and take advantage of what Foul Play is given to you for free. Well, free to them, it costs Foul Play and it costs, different team members and whatever, pulling money out of their pocket. That's how important it is to us to get the truth and get the information out there for other people. And I do that as much as I can in Daniel's case. And, I think that Foul Play is, I don't want to say a phenomenon, but definitely an epic community of wealth of knowledge that people with open minds who are really interested in truth will take advantage of. And I'm just proud to be a part of it. To be honest with you, I don't do all of the deep research, but when it's presented to me, I listen to it, or I read it, or I take it into consideration, and I take the advice and opinions of those around me who are very good at the research and doing the FOIAs and getting all the information. That's all very important to me. Dr. Silkman's experience, in forensic science and DNA, that's hugely important to me. Why wouldn't anybody have to have the same feeling or desire if they're truly interested in truth and justice? And like I said, I'm just proud to be a part of it. See, Scooby, I told you I've come out of my shell because I didn't used to say much, and now I can't be shut up. So They give me an open mic and I take it and run. So I'm just proud. I'm proud of Foul Play, and I'm very honored and proud to be a part of it.
You know, same here. You know, and even beyond, you know, any open mics or any of the other different formats that we presented information, there are thousands of radio and dispatch calls. There's I'm gonna guess around 1,800. I haven't counted them. Different phone calls between Steve and Jody, and Steve and other people, Jody and other people that have been, you know, we've made little clips. You know, you have to put it in the MP4 format before you can upload it to YouTube. So that work has to be done. But you know, the thing with Foul Play, you know, we're willing to listen to uh, pretty much whoever that has a civil wants to have a civil discussion. But I think for myself, and I won't speak to everyone in Foul Play because this is just me. I prefer to be ground in something that I can wrap my hands on. It's fine to speculate, which we do. We see end result of something that's happened without seeing part of that event that led to that result. We can only speculate about it, and that's been a real problem. It's a problem today. But I try to stay away from too much conspiracy stuff because I can't even make an intelligent leap. I can't. I'm not blaming other people if they do. That's fine. I'm okay with that. I just can't. So I prefer to be ground more in the truth of what we can put our hands on in a document, in a call, in a video, something that's been said or presented to us. One last thing I'll talk about is DNA, and you talked about, Travis, how careful you have to be with DNA. And I specifically remember Gene Couché talking about DNA in his deposition, and he was really crafty and really kind of eye-opening in what he said about DNA. DNA can be transplanted, unlike fingerprints are unless it's on an object, fingerprints are very difficult to move and plant on someone. So DNA opens up some really good doors and some really bad ones.
Am I muted?
No.
I just wanted to, I wanted to kind of look at a comment here that, and it really bothered me. And if I'm not mistaken, I made a really lengthy response to it. A recent comment on my most recent video that we did. Let's see. Let me just find it because it was really
Oh, that Gilter?
kind of, yeah, one of the guilters. I've not encountered guilters really on my channel until this last video, which was fine. But okay, she says this person says in my comment section, everyone has to fight for something, but this is a weird flex to. Okay, now listen to the way she phrased this, or he. Um, this is a weird flex to openly support the wrongful conviction of a rapist. And then it goes on to say there's no punctuation. Just remember that correlation does not imply causation. And I thought, and I responded like, of course I'm going, if I, and this is just me, and I think a lot of us in Foul Play and Travis and others, if I had just sat back and just let, Stephen and Brendan's cases stew in my brain and wondered and never really known and not had the experience of knowing how to research and just let it go, I would have just been, and then of course in Daniel's case, if I had just saw, what I saw Daniel in the den and then started listening to Brian Bates and then just sit back and just not get involved somehow, it's, to me, that is not a weird flex. That is for me, a moral thing that I have to do. It's just something that I'm truly interested in, and it's not at all what I expected to be doing when I got my bachelor's degree in criminal justice. Nothing like what I expected to be doing. I actually didn't even really know that wrongful convictions were a thing. But the way this person said that is, I just thought, I just said, you know, sure else I'm gonna look into something like that and be a part of that and do what I can as a, you know, average human to see. I don't. Nobody else has to do it. Everybody else doesn't have to do it. That's fine. But to say that the way it was said, I just thought you. It's a weird flex, and then to openly support the wrongful conviction of a rapist. I don't know. I just didn't make sense to me. Um, just remember that correlation doesn't imply causation. I just, yeah, you know, do what you want to do. You know, believe what you want to believe. Research what you want to research or don't. But yeah, I'm not just going to sit back and let it go. I couldn't do that with Stephen and Brendan's case, particularly Brendan. And I'm certainly not doing it with Daniel or any other case that I come upon, you know, in the future. I'm too involved right now with Daniel's case to really give any other case, you know, my full attention. Although I have told Amy that I would do everything I can when I can to help her with the Ashley Garth case. But I don't, you know, if you don't want to be involved in this type of advocacy work, activism, whatever you want to call it, then don't be. But don't, you know, it's kind of weird to be critical and tell everybody else that they're wrong just because you're not interested in it or you believe something different.
It's disingenuous to me. I want to add one more thing.
There you go.
I want to add one more thing to what Rhonda's commenting on before Cherie comments. For me, another part, and I was really fortunate, Travis, in my early high school years, I had a really, really wonderful civics teacher. This guy really got my introduction. Of course, I didn't follow the path into any kind of legal thing, but it caught my interest at a pretty early age about our Bill of Rights, our Constitution. And he would actually set up arguments. Now, this was ninth grade, so we were pretty young, you know, 13, 14 years old, and trying to understand the legal system. But he was really great at posing these arguments from different cases he would look up. You know, nothing terrible, but certainly that it would involve our Bill of Rights and him explaining the process. What I see has happened in the last 30, 35 years of my life. I'm not a young chicken anymore. Is the erosion of those rights. And EDPA was and to me, was it's some of the most terrible set of parameters and laws, whatever you want to call it, that has ever been passed in our criminal justice system. There were other ways to get control of the habeas process that I think they just went too far. And that's my opinion. Anyway, Cherie?
I was just going to add to what Rhonda was saying, or just say that what that commenter said made no sense, you know. It just didn't make sense the way she worded it. But, you know, obviously, if we thought he was a serial rapist, it wouldn't have been a wrongful conviction, you know. But anyway.
So the adage that, you know, they're borrowing from, that correlation doesn't imply causation, but that's not what you're doing, or at least what I've seen you do on your episodes. So, you know, an example of correlation not implying causation, and this is actually factual. Ice cream sales and shark bites. I wish Silkman was in the chat on the panel, but because
I'll try to get him.
He could talk about this in Australia, but in the United States, there's over 95% correlation with a very high confidence level between ice cream sales and shark bites. So does that mean that consuming ice cream makes you more susceptible to shark attack? Of course not. When do we eat ice cream usually? Warmer months, right? When are people in the ocean? Or I guess there's a golf course that if you try and fetch a golf ball that you've lost, you've got a big chance. But yeah, correlation doesn't imply causation. So big deal. That's not what they're doing. That's not what Rhonda's doing in her channel. You know, the biggest adage, Rhonda, I would share with you is that, one comment does not establish a data point. If you think about that for a minute, that'll sink in. But, it's okay. Look, I'm going to show you these depositions. I'm going to show you these videos. I'm going to show you what they testified to in their deposition as compared to their trial testimony. I'm going to show you what the investigators promised. I'm going to show you how they were interviewed. I'm going to show you under what circumstances, whether they were in jail, facing criminal charges, where they had opportunity to maybe get drug treatment to avoid more incarceration. That's not correlation implying causation. It's simply, here's some things you might want to consider as to whether this person received a fair trial. And, that's a different thing about Shri and I being in the legal aspect of it versus the true crime genre, enjoying the entertainment aspect of it, where it's perfectly appropriate in that context by the water cooler after seeing Making a Murder or any documentary on true crime, or reading a true crime book, or following a trial in your community in the local paper, or seeing televised a 2-week impeachment hearing of your attorney general. It's perfectly appropriate to say, he's guilty or he's innocent. But in the context that Shri and I operate in, it's never that. It's did the person receive a fair and legal trial? And it kind of takes all of that out of it. And what Rhonda's doing and what foul play does, it's like, I'm making this information available to you. You make up your own minds. Here's, I'm going to show you these materials, and you can make up your own mind and go from there. But it fancy to say correlation does not imply causation, but doesn't mean much more than shark bites and ice cream.
Right, exactly. Well, and that's why I guess I was confused by the comment. I just thought, well, that's not what's going on here. But the way you explain it, though, yeah, I can see the difference between entertainment and, factual information, I guess, so to speak. So that makes sense.
I don't know if they even explained it that well, but you don't come out and say, well, and there are others at the beginning of that case that were commenting. Again, it started out, private investigator for Daniel, and I'm extremely limited by what I can comment about Daniel's case because I was.
I'm not asking you to make any comments, Travis.
Yeah, I was one of Daniel's attorneys on a limited aspect of the case, but the initially there was a private investigator that was working for Daniel's trial attorneys that did some episodes on YouTube, as I recall, and he was explaining the problems. And Rhonda was in there right from the get-go, and a person by the name of Mitch who started to have health problems. But in any event, so we've got to, we've got to get the transcripts, and we got to get the documents, or you're just spinning your wheels. And that's how I initially got involved. Came up with some mechanisms to where. A team would have full access to all of those materials, restricted, but and unable to create a library. But someday that will come. But having those materials, but people were commenting. Eric Jose did a couple of episodes about Daniel's case, and people were commenting. Oh, well, they're all, crack users, engaged in prostitution, et cetera, et cetera. Yes, correlation does not equal causation. Being a crack addict involved in street crime like prostitution does not equate to causation of being unable to tell the truth about anything. That because you use crack, because you engage in prostitution, you're incapable of telling the truth. That's an example of correlation and causation. However, those things coupled with other things can create a bias or can create a motivation to be untruthful. And in the wrong hands, just like DNA, if you're an addict and you've been locked up for 2-3 days, unable to use your drug of choice, and things are dangled in front of you in the wrong way, that can be a strong motivator to say things that may not be the truth. And that's how I've seen Rhonda present those issues. But it started out a little, not from Rhonda, but from others, people commenting, they're descriptors for people that use rock cocaine in urban areas, and and then it's a thorny issue also, in terms of demographics and crimes against women, and it's just it's thorny. It has a bunch of issues that you have to be careful with, and there people are going to look at those cases that they may be staunch supporters of Stephen and or Brendan, but absolutely 100% convinced that there were no problems in Daniel's trial, or 100 others. And it's just because of the biases we all have. We might have a family member that was a victim of inappropriate conduct by a police officer of a sexual nature. We may have a family member that's a victim of a sexual assault where there was, they were able to assault that person because of a disparity of power. But we all have those, and it's people can be on the different sides of the supporters of in one area, may not be, and vice versa. But that's okay because the format's the same. I'm going to give you everything I'm able to give you, and you decide. But the analogy about correlation and causation. But if we'd had Silkman in here, he'd be able to tell us all about shark bites in Australia.
He must be busy. I did send him a message, but he told me that he has some things to do. Well, it's his morning, so which he often does on. It's our Sunday, but it's his Monday morning, so I'm sure he'd join us if he can. Another thing about foul play. When I came to foul play, I was just out there doing what I do. And I got invited. I was in Eric Cose's Discord. I did participate, not a huge amount, but I did discuss things and so forth. And again, it was never my intent to get on voice. I resisted that for a long time. Even then, when Richard had the first Mammothon that we did, online. I talked to, it was actually Jamie and Richard that talked me into even coming on and talking at all. Because it just wasn't something that I was really interested in. I'd already seen some issues that cropped up, and I never wanted to be a part of any of that drama bullshit and getting involved in things that were irrelevant. I can disagree with a number of people about a number of things within this case, other cases too, but specifically this case. I'm not mad at them. And hopefully in that civil discussion, they don't get mad at me. Foul play team members, we disagree all the time. But we work, as Rhonda said, we talk through it. And we want to present people with good information that we found, we think is relevant and truly important, and let them make up their own damn mind. We're not trying to specifically change anyone's mind. These are just things that we see. And as Rhonda discussed about this other person that made the comment on YouTube, we get a lot of that on various social media platforms. And then when you try to pin down these people about X, Y, and Z, they want to change the subject and deflect. Oh, well, Stephen, he did this and he did that, but 40 years ago, it has absolutely nothing to do with what you're talking about. They will not admit. Well, some of them will, but the majority will not admit fallacies in the investigation, fallacies in the prosecution. They're proud as hell to talk about, oh, we had this great prosecution and Ken Kratz and blah blah blah, but they wouldn't have that guy near them in real life. They wouldn't. They've made that distinction, and I'm like, well, if he's such a good guy, why wouldn't you want to be his friend? Why wouldn't you want to have him over dinner, take him out for a beer, whatever? And they won't do it. Some of them will completely avoid the subject at all. So it's really an interesting dynamic. Getting back to the folks that what we try to present as much as we can. Now I'm going to tell you, there are some things we won't publish. We just won't do it. Brendan's phone calls that Zoe requested way back years ago. He specifically asked for those calls for us not to publish those calls, and we've honored that. I mean, there's been a couple that have been published. The unaired Anjanette Levy interview that she had with Brendan, which I really just I hate it. I hate that interview, and I really hate the fact that they didn't air it. It really bothers me, and it maybe shouldn't bother me so much. But presenting good information to people, let them make up their own mind. If you want to disagree, fine. Do it civilly. We can talk about it. I'm okay with if you don't agree with me. Just don't be an asshole about it. It's just that simple I think for all of us, right?
Yeah. Well, yeah, for me too. And Jack, kind of going back to what you said about, guilters, bringing their thoughts and their opinions or whatever about Kratz or whoever, you know, he this and he showed this and he proved this and he proved that.
I mean, there's been
And
a
then
couple that have been published. The
my
unedited.
practice, hello? Oh,
Uh,
my
Travis.
practice I'm working on, what I'm working on is trying to, when I've, kind of gone back and forth a few comments or whatever it is, wherever I'm at, about my beliefs and why I believe what I believe, and then this other person is saying, yeah, but, yeah, but, yeah, but, and
Right.
and
With no
but like
explanation.
you said, with no explanation and nothing to back up what they're saying,
That's
then
right.
I just say, oh, okay, then you know what, I'm done conversating with you because you're just here to argue and try to piss me off or whatever.
Well, it's
And
troll.
when I get to that point,
It's
then I
troll
know
stuff.
it's,
It's troll stuff, Rhonda. To me, it's just
yeah,
troll.
yeah, it is. And I
So
realize that, and I just like, okay, I'm done with you, peace,
so let me give you
So,
guys
yeah.
one more example of correlation doesn't imply or equal causation
Travis.
before we hear from
Travis,
Dr. Silkman.
Yeah, Doc is here. Hey, Doc.
But one
Hey.
is acts of a person 20 years prior they may have engaged on when they were a teen or in their 20s, robbing places or being in altercations with former spouses or whatever it might be, doesn't mean causation that they are a murderer. You have to prove that in court with evidence. The courts have seen we as humans are wired in a way that we think in a linear fashion, so we can understand algebraic rise. The human mind has a very difficult time dealing with exponential growth. In the pandemic proved that. The scientists were warning in dire terms in February, March, April, what was coming by summer, and it was just dismissed and unfortunately became a political issue. But sure enough, the numbers that were predicted in February and March were there. And even more unfortunate is the deaths that they predicted, if things didn't happen, occurred in the United States. Courts realize that juries put a lot of emphasis on bad acts of a defendant.
Yep.
And so they exclude them. Like in Stephen's case, they tried to bring up all of these things that we all know about. We've known about them forever. And there's a reason why the court excluded that. We don't convict people for being a bad person, or we don't convict people with whom they associate. Dr. Silkman, thanks for joining us. Tell us about the sharks and the kind of ice cream they have in Australia.
Well, the sharks are extremely dangerous. We've got massive white pointers all over the place. That'll make people that watch Jaws very envious. The ice cream in Australia is incredible. There's a lot of fantastic gelaterias, so to speak, with many, many different flavors. Travis, you're coming down to Australia, is that correct?
I'm coming to see you. You bet.
Well, my advice is avoid the sharks and eat a lot of ice cream.
You guys have so many things down there that can kill you. You have seashells that can kill you. You got octopuses that can kill you. I mean, you got these toads that are
Spiders.
infestation that if you lick, you
Oh yeah.
hallucinate. I mean, you got everything down there.
Hey, Travis, you know that
Judge
everything
Mike.
in Australia, there are probably so many. Well, let me just put it this way: everything there is trying to either kill you or has a plan to kill you.
Correct. And it's not just the attorneys, right? Look, Australia, which is almost as big as America. Australia is huge. There's a lot of contrast in Australia, from like tropical forests to massive deserts. A lot of Australians live around the coastal areas where we have beautiful, beautiful beaches. But you're correct, Travis. Australia has got some incredibly dangerous animals and insects and other bits and pieces that either want to kill you or eat you. But look, if you pay respect, they'll leave you alone. That's for sure.
Yeah, Doc, Travis had commented on our format and how we, I think, generally approach this case, even other cases. What we see and what we've been able to glean from the documentation, which we rely on their documentation to prove our point. And I think we've been very successful in that, even if we don't necessarily agree within the group about all aspects of what we're presenting. We still present it. And if people want to disagree, that's fine. I don't have a problem with it. And hopefully no one else does either. I certainly don't want to make anyone upset about my opinion. I try to think through things reasonably. And again, I said it very early in today's show that if somebody can, well, not very early, but if someone can prove to me that Stephen and Brendan did this, fine. My allegiance is to the truth, period. And I think that's where Doc is. I think that's where most of us are within the group.
Yeah, and that's why I love being part of the Foul Play team. I can bring along some of my expertise, but also foul play is the sum of all its parts. It's not one person or a group of people, it's all of us. And the other important thing, of course, is the people in chat that come along and support us, provide feedback. Sometimes it's harsh criticism, but we do take it all in. And we're also blessed that we can invite people like Travis, Cherie, who work in the legal profession, who can share their wisdom and their knowledge, things that I'm not well versed about. And I think in foul play, what we try and do, and I believe we've done it very successfully, is produce a safe, conducive atmosphere where people can present their ideas, their theories. We can hash them out. We can discuss them. And, when you consider that Foul Play, the YouTube channel, has had over 1 million views. 1 million views. Think about that. 4 years ago, we had 0. And now we have over 1 million views. We've done thousands of podcasts. We've got an incredible library. Yoriz and other members have done fantastic work where they've done 3D interactive maps, a hell of a lot of information, and we give it away for free. So, which means what everyone should do, hey, come along, read the official documents. And Travis made a very important point. If you're going to talk about a case, you better make sure that you go to the original trial documents without any form of bias, without any form of objectivity. Have a read of the documents, interpret them in the manner that you believe is correct, discuss them, present them. So I'm very proud that what we do here is that we don't rely on just being speculative. We present the original documents for everyone to read, see, discuss, and they're available for free. We don't hide anything. If you disagree, write down a comment. I All of us, we check the comments, we give feedback. Look at our podcasts, right, Jack 61?
That's right.
I did the reading with the crew with Neverly, this chapter, 3 months ago?
Yep.
And we're still going. You know why? Because people ask questions and I go, oh, okay, that's a really good point. And I go back, research, find the original documents, and you, Jack 61, provide the phone calls, everything, and boom, we present it. And that's why I really like this environment where we can be proactive, not reactive. You know what I mean? Which means that we are constantly evolving, adapting, and listening to what people say. And, you know, in regards to convicting a murderer, yeah, we will do a rebuttal, but let's see what they present first, because they may show something in episode 4, and in episode 8, they provide a different explanation. Do you know what I mean?
Right.
And you look like an idiot.
That's
So
right.
it's best to wait. Once we've got everything, we can then go back and take it apart. Just like we did with Kratz's book, with 63 podcasts, over 400 hours of analysis. You're never going to get that anywhere else. So in that regard, I think we do provide a great environment for our panel members, our staff members, and everyone in chat. It's a blast. It's been a blast. It really has.
Yeah, you know, that's you talked about speculation, Doc, and truly, I mean, and I remember it well. Back in January, February, even late December 2015, going into the 2016, we, as I said earlier, we didn't have anything, and that's what it was. It was a speculation contest. That's all we had, and that's why so many of us were so interested in getting this documentation at least started. You know, trial transcripts, as Travis said, the pre-trial, the motions, the police reports, all this stuff. We wanted to truly understand the glimpses that we saw in Making a Murderer, because they couldn't put everything in there. It's impossible. There's just no way.
Correct.
Anyway.
And you are correct, Jack 61. The obtaining the original documents and documentation is crucial to removing speculation.
Yep.
Remember, it's so funny. During some of our past episodes, we're going, well, remember the picture of Teresa Horbach, the missing poster that was inside the office of at the Avery Salvage Yard? We're wondering, who the hell put that poster up? Was it this person? Was it that person? By going through the documents, we found out it was a person who went through before Pam of God did. He insisted on putting up that poster in the shop, and Earl said, yeah, no problems at all. That's good research. We never speculated. We're wondering, okay, who could have done it? By finding the original source, we were able to dispel any rumors or innuendo. Boom, another check mark off the list. And so by doing what you said, Jack 61, by referring constantly to official documents, you avoid the crap, the speculation, the innuendo, stretching the truth. You say it as it is. And I think that's important.
Yeah, I never want to put out misinformation or even innuendo. I mean, it's some of that innuendo is a little hard to avoid, just because, again, we see end result without actually seeing the actions in between that caused that end result. So again, it forces our hand, if we want to continue the conversation, to say, okay, this, it appears happened. We can't prove it, so it becomes speculation and to some degree innuendo. Travis? Travis may have stepped away for a minute.
I'm here.
Oh,
So something you mentioned, so there was one website that I started on, and may have been you, Jack, but what was the one that's been defunct for a few months?
that was StephenAveryCase.org. That's the original website that Skip Top put up way back when we started getting the documentation.
So, so the point is that, and there was a tremendous amount of information there, most notably the trial transcripts and the pretrial transcripts and the trial exhibits and so on and so forth. But you all didn't stop there.
No.
You went and said, well, okay, well, how do you get documents and open records requests? And, you know, it spurred even more in-depth attempt to try and connect these dots. And then obviously you just mentioned some of the frustration because you know the end point, the phone call. You know, why is this person asking to get somebody to follow a vehicle to the Wisconsin crime lab? You know, what's that all about? Some of that stuff you can kind of figure out, but
Yep.
it's not really innuendo. In my view, it's, you know, it's a good faith attempt to try and answer the questions that started out were raised by ma'am making a murderer, and then it was like trying to understand DNA, and I don't know exactly how Eric Jose got hooked up with Scooby, but there was a number of presentations on that. Then, of course, Dr. Silkman, and you know, because it's a huge part of the case, and just trying to understand. Okay, well, what is, you know, is there enough to, you know, did they have enough to say that mitochondrial DNA establishes a link with this individual, or, you know, or whatever it may be. And, you know, I learned a tremendous amount. Blood cells, after a day or two, shed their nucleus, so so that they can fit through capillaries one at a time. And, you know, just a lot of great information. And the only way you're going to know 100% is if it's either on video or you were there. And even video from police cases, you know, a lot's depending on the angle of the video and whatnot. And if you were there, you'd be a witness or, you know, a co-conspirator. And so you just never have what you would like. So you do the best you can, but you know, you don't just sit back, you guys I'm referring to, and say, okay, well, we had all of these documents from StephenAveryCase.org, and, you know, I'm going to end it there. No, it's like, well, let's see if we can connect more dots. And yeah, my opinion may change based on that, but I'm not afraid of that. I mean, it just says a lot that, one, you put it all out there that everybody can see and make up their own minds, or even use against you in some format or some forum. It says a lot that, no, you know, here it is, read it, make up your own minds. If you don't have the time, ask the questions in Discord, and we'll help you find a quick answer.
Yeah, that's right.
And, you know, so, and like you both all have been saying is, based on those facts, you know, nobody's entitled to their own facts. The facts are the facts. You know, there's document X and there's photo 27, there's video this, and then y'all come up with conclusions, and I've never seen anybody lay out a theory that was disrespected in any way. I've seen polite questioning. It's done in the scientific journals, peer-reviewed journals, all the time. Uh, Polite questions and testing, and we've already talked about in previous episodes that I've done about defending a dissertation, and it's not really debate, but that type of testing of theories, and scientists do that every single day, and so do lawyers, but in a different context. But it's healthy, and I hope you guys continue for a long time while we wait for this latest appeal to work its way through the process. But
Absolutely.
that's my thought.
Doc?
Oh, absolutely. I mean, there's still a lot to uncover and connect the dots. And that's really highlighted by the chapter that we're doing at the moment with the canine noses. I'm finding connections which I never were able to connect the dots previously. The name Sergeant Jason Jost never even entered into my psyche, nor was Sipple. I knew about the Manitowoc County gravel pit, but now Mickle's Quarry is coming into the picture. And by looking at all these things in an objective manner, putting them out there, getting the documents and getting feedback from the panel and people in chat, we are now able to look at a situation where planting of the bones is a real phenomena. The greatest challenge that we get from guilters is, okay, how are you going to prove that a planting scenario took place? In order to have planting taking place, you basically need the opportunity to get your hands on the forensic evidence. You also have to have the means whereby you can plant that evidence at a specific location. And I'll tell you what, Sergeant Jason Jost ticks all the boxes. And that's come about through a lot of very hard, diligent work, by being very careful, being very scrutinizing, not leaping to any conclusions. But, when you have events that are taking place at strategic times by specific individuals, you have the means and motivation and ability to plant, right? Because when you accuse someone of planting, that's very, very serious, right? So you've got to back up your statements, right? And I believe that we are doing this in a systematic, fair, and academic manner by placing on the table all the supporting documents, and of course with Jack 61, with the phone calls, and also incredible findings by Duke. He didn't know who foul play was. He never was a member of foul play. And when he joined us, bang, everything is falling into place. And I think that goes to show the power of doing research in this manner by looking at things from a different angle and perspective and joining the dots. And I think we are doing exactly that. What do you reckon, Jack 61?
Well, one of the really more interesting things, and it's a huge red flag for me personally, is Holy Jost didn't want credit for pointing out this bone that was allegedly found 8 feet south of the burn pit. He tells his boss, Deputy Inspector Shetter, well, I just kind of point him in the direction. He wasn't even going to write a report, and that's really interesting to me. This is right up there with the RAB as the most significant fact in the case, period.
It is. And I think also, guys, it's very, very telling of who never takes the stand. And it's amazing that people who had their hands on critical evidence, for example, Sergeant Jason Jost never gets called to the stand. Sipple never once gets asked about the cremains at the burn pit.
Nope.
And isn't that incredible? And the guy who found the clandestine burial site, he's disappeared, like Jost, Mike Bushman,
And
who's
no
a
report.
canine. No report, and he's a canine dog handler. So, you know, a lot of guild are saying, come on, how many people do you think are in this conspiracy? And the answer is very few.
Very
Very
few. It's a small number.
Very few.
Guaranteed.
You think about it. You move cremains from one spot to another, and those people who find the cremains, they're innocent. They've got nothing to do with any planting. They report what they find, right? But the question is, the anecdotal evidence suggests there were no cremains there. There were no human cremains there until Jost started pointing a finger at them. And the evidence is so powerful, right? You can't have cadaver dogs and scent dogs completely bypassing the burn pit, showing no interest at all. And, you know, these were really tough questions that were asked by Strang and Buting. And eventually, they answered it in court, right? And Fallon and Kratz, let me tell you now, and Travis will back me up, they objected strongly any time something really challenging came up in court, be it talking about the cremains, be it talking about the phone calls, be it talking about the voicemail messages. Kratz and Fallon jumped up and down, and not only that, got the jury taken out of the courtroom. Now you tell me why. If this is an avenue to find the truth, why don't you want the jury to hear it? There's something not right here, guys.
Yeah. Yeah, I would agree with that. You know, drawing our own conclusions from this information that's been dug out of the, you know, trial transcripts. We read some of it yesterday, talking about the dogs didn't hit on the burn pit. Fassbender agreed they didn't. You know, and that brings another question to mind. If they thought, you know, at that point on the 8th that Sipple or Jost and then Sipple had found something, why didn't they bring a cadaver dog over? They were everywhere. They were all over the damn place. It would have been easy to have brought a couple of cadaver dogs to see if they indicated. And that didn't happen.
I think most damning, Jack, is that they never called their boss, and their boss never showed up.
And Uyghur and Fassbender didn't show up. They didn't call them, the lead investigators. I mean, what the hell, man?
Yeah, if you wanted to point a finger at Stephen Avery and really drive the message home, you would have immediately called in a coroner. You would have brought in a video camera. You would have taken extensive photographs and basically say,
forensic anthropologist.
Forensic anthropologist, and say, well, Stephen, how are you going to explain this?
That's right.
And their behavior at Stephen Avery's burn pit says a lot, because the way they sifted the burn pit, it was done in a clandestine manner. It was done very quickly, and they got the hell out of Dodge. And let me tell you right now, you compare and contrast with what happened at Cuss Road, and you could immediately see the difference in the attitude and the amount of resources at both events. Now, if you're Sipple, if you're Jost, you should be pronounced as heroes of the investigation.
Absolutely.
You have found the victim. You have found the victim.
That's right.
None of them wanted to touch those bones. No, it wasn't me. It was him. That's bizarre attitude to have, guys. Really is.
It is. Go, Travis.
Yeah, I've never seen anything like that, because Sturdivant, you know, when you guys started talking about this, and Jost, who's Jost? and Jost, essentially, other than the RAB, you know, cracks the case. Certainly, so the RAV's there, and that's 90% of it. At least that's the way they reacted. That's why Strang played the radio calls he did in the opening within how many ever minutes of discovering the RAV. You have all of these calls. They basically had convicted him, was his point in opening statement. And the next thing was, okay, well, now we need to find Teresa. So Jost essentially finds Teresa, but yeah, he didn't want to do a report. And then fortunately, you had the lieutenant, Kelly. What's Kelly's last name?
Sipple.
Documenting that all out. And then you've got Sturdivant, who has some arson investigation experience, writing it up like he's the one who discovered everything and put it all together. And it's just like, and the one key thing for me, I asked a question when you guys were going through this is, who is Jost with? What agency?
MTSO.
And then, of course, you told me MTSO. And so I said, so every significant piece of evidence other than the RAV was discovered by somebody from MTSO. And I think y'all mentioned one or two miscellaneous pieces, I would call them, but FL, the key, on and on and on, MTSO. And what are the odds? What are the odds this guy's just so anxious, he's standing around? I'm going to go to the command post and talk to Lieutenant Sipple, who's with CASO. The agency brought in so there wouldn't be a conflict, and said, I don't think they're checking the burn pit enough. And then you heard about, I mean, you look at that is one of the craziest things I've ever seen. I mean, just the black and white four corners of the reports. I mean, you don't have to be in law enforcement. You don't have to have had hundreds of cases where you read hundreds of reports. I mean, something, the earth is flat when it comes when you connect those three reports together. There's something just isn't lining up.
Yeah, 100% correct. And you see, Travis, you could only do that by being hyper vigilant and not taking any document at face value, but actually comparing and contrasting. And that's why here at Foul Play, we spend a lot of time looking at the minutiae, because by comparing reports, you can actually compare what each other has said in regards to the burn pit. I mean, let's don't muck around here. The burn pit is the quintessential piece of evidence that nailed both Stephen and Brendan, because the state is saying that that's the primary site of cremation of Teresa Horbach. And we're presenting anecdotal evidence. And even the experts of Kathleen Zellner are saying, you've got to be kidding. You cannot cremate a person in such a small burn pit, 4 feet by 5 feet. And look at the ash pole that's been left behind. There's very, very little ash. There's no evidence of any ash or soot anywhere else. It clearly cannot be the primary site of cremation. Yet, the jury believed it. The jury believed it. And they found Stephen Avery not guilty of mutilation of a corpse, which is completely bizarre. Yet, they convicted Brendan Dassey on that. And he even said in his confession, oh, me and Stephen, Uncle Stephen, we picked up Teresa Horbach and placed her in there whole. Well, I'm sorry, but the forensic anthropologist has shown evidence that there is dismemberment. She was cut to pieces. She was cut to pieces. So when you look at the evidence, it doesn't stack up. Brendan Dassey got every fundamental issue wrong or never discussed it until his interrogators, Fassbender and Wiggett, were telling him what was occurring in the case, which is completely bizarre. What do you think, Jack 61?
Oh, it is, absolutely. You know, and we've discussed it before, and I'm sure it'll come up again. You know, Brendan was a pawn because the thing is for me questioning why Kratz waited basically 5 months to go after him. He knew in early November that Brendan said he was there helping Stephen burn brush and so forth in the burn pit. He knew Brendan was there. So what was this waiting for 5 months about? That's another huge red flag for me. And it drives me, of course, to speculate, which I won't do now, but there had to be a reason for that. And of course, I was waiting for, I think, others to take action to feed stories to Kayla, even probably some degree to Marie, but it was Kayla, you know, that really got that whole direction pointed to Brendan and got him looped into this. And the poor kid couldn't defend himself. He just couldn't do it.
Oh, correct. And not only that, Jack 61, but convicting a murderer has shown that the entire family or families are in complete, utter turmoil.
Oh, absolutely. Now, that's on purpose too, Doc. There's no doubt that's on purpose.
Right. And that happened not now. That happened at the start of the case, at the start of the murder investigation, whereby the investigators like Skorlinski and others were turning family members against each other. Oh, of course your brother did this. Your brother is such and such. Oh, what do you mean you did this? You know that it's illegal to burn tires? Or what do you mean you operated the crusher with it? They were threatening everyone in that family, including Bobby Dassey. They were all... Yeah, they were all pawns in a very, very sick game. And I suppose, really, Jack 61, they were waiting to find some type of forensic evidence against Brendan Dassey. In other words, when Culhane was looking at all the evidence and doing all the DNA preps and things like that, they found no fingerprints, no DNA, no hair, no nothing. And all this rape, mutilation, destruction, killing, dismemberment, shooting, they found evidence of nothing. Nothing tied Brendan Dassey to Teresa Horbach. Nothing.
And nothing tied Teresa to Avery's bedroom. The dog didn't indicate at all.
You can't tell, you can't manipulate a cadaver dog, right? Now, they all went into...
No bias, right, Doc?
No bias. They went into the Brutus, who's their best cadaver dog, went inside his trailer, completely bypassed the bedroom where all this mayhem went. Nothing. No alert. Yet alerted on blood droplets in the bathroom, which meant that Brutus was able to detect small droplets of blood on the ground or in the sink, which meant that the dog was doing its job. Now, wait a minute. Are you trying to tell me that a double rape and torture and mutilation and all sorts of nefarious things took place in a bedroom and the dog doesn't pick it up?
Yep. I'm calling it shenanigans and bullshit, Doc.
That's shenanigans and bullshit. Are you trying to tell me that a cadaver dog just bypasses the burn pit containing all of her, a great proportion of her cremains and muscle tissue? No cadaver dog decides they want to do a beeline towards the burn pit? I call shenanigans and bullshit on that too, Jack 61.
Well, I think we've gleaned from those documents, you and Duke and others have done this really deep dive into the activities of the dogs. I think they used the dogs to their own benefit and left it out for Stephen's benefit, right? That's what I see.
The dogs were telling a narrative that the state could not explain. So
That's
what
right.
they decided to do was they left it out. They left it out. But the incredible thing is, the more you look at the documents and trial testimonies, especially in the pre-trial,
Oh boy.
it gives hints and clues that now make perfect sense.
Yeah, and that leads us into this area because we see again the end result without having some of that middle section filled in, and it does. I mean, I think our connecting these events is probably as close as we can get, at least right now. Hopefully, we can get more documentation soon. I want that documentation on Jost that I've requested that
Yes.
has never been, as far as I know, seen. That brings up I won't go into it, but the unfiled warrant about disturbed earth, that was a huge thing.
Massive.
It's such a frustrating thing that this thing, whatever the hell it is, just disappeared. We talked about yesterday, they were looking for a specific piece out of Teresa's Toyota RAV4 toolkit.
Oh, a
And they
tool.
never,
Yeah.
yep, and the tire tool, they never found it, as far as I know. Or unless it's the blunt and bloody instrument that never got entered into, it was never tested or anything. So, there are many things that we can talk about that could potentially be explained that might make sense, but there are many other things, and this is my real interest, and I think for Doc and so many others, there are real questions that are never explained, and they're important questions. These are not just the fly-by-night stuff. I can talk about right now this discussion. We talked about it earlier, Doc, before you came on. These discussions that Fallon and Zellner had, and she wants the unedited flyover tape. She wants it, and she's been asking for it apparently. And then Fallon sends this he's pissed off message to Wiegert, and I don't remember who else is in that email heading, but we got to get that second tape working. Well, what
Yeah.
second tape? What the hell are you talking about? It's never entered into evidence, and we've never seen it. To this day, we've
Correct.
never seen it.
Well, it goes to show Jack 61 and everybody else how damning a videotape actually is, because
Yep.
a videotape will pick up stuff that you would never ever would have thought of. Look at those two detectives that did a walkthrough on November the 6th.
With a
They
bear.
picked up Bear. They picked up Bear walking along, and no one ever thought of that. As soon as I saw it, my jaw dropped to the ground because the lady, a detective, was standing in the same position next to the propane tank as Julie Kramer was, because she approached the propane tank. You notice that Bear never charged the lady, and
Right.
right next to the propane tank, next to the garage, is exactly where Bucket Man would have been standing. Bear could have easily got to him, and yet Bear was right in front of him, which dispelled a very important tenet of what Kratz tried to sell to the court, that the reason why they never found bones until the 8th was because of a large, aggressive German Shepherd. He was anything but.
Well,
And
yeah.
that's a key cornerstone that we have debunked, demystified, and destroyed. It now has opened up the avenue of an officer planting cremains at the burn pit, because all he had to do was walk straight up to it. There was no large aggressive dog. The dog couldn't give a damn.
Right. He
There you
probably
go.
barked when he probably barked at them when he first got there because he didn't know who they were. And then once he saw that they were just people milling around, he didn't give a shit.
Yeah, and no dog is going to argue if you come up with a bucket of goodies and food.
Of course not.
Good dog, good dog,
Good boy.
good dog.
Good. Yeah.
Good
Good boy. You good boy.
Correct, correct.
Yeah. All right. Well, I guess we're right at. Let's see here. Well, we're a little over 4 hours. I think this is probably, unless there's other questions or comments, I think this is probably a good time to call it done. Doc, Travis, Rhonda, anyone, Cherie.
No, all good for me, Jack 61.
No, I'm good.
Okay, Cherie, you got any comments, questions before we get out of here?
No, I'm good. It's been an interesting discussion. No.
Absolutely. Travis, any final
Would just
thoughts?
like to
Nothing,
sorry.
nothing from me. I think we covered it all. I think I'll conclude with this. Much smarter man than me said, let me see if I can get it right. This is Walter Lippmann, by the way. There's but one kind of unity possible in the world as diverse as ours. It is unity of method rather than aim, the unity of disciplined experiment. And I'll end it with that.
Excellent. I think that's an excellent thing to say.
As a ripper.
Okay. I want to first, number one, thank Travis and Cal. I know I think today is, or tomorrow is her birthday, so happy birthday, Cal. She had, I think, other things to do today and couldn't join, but I know she helps Travis immensely with his research and so forth. And I certainly want to thank Travis for coming on and doing a part 4. We'll continue this series as long as he's able and willing to talk about this process. Please, I've put in to the live chat a number of times our link to Discord. There's a room specifically in the open mic section to ask your questions of Travis. He'll answer them. Hopefully, we can come back soon to do another part of this series. I love hearing him explain the legal acumen in a way that we can understand how the court works, what they look for, what they want, what they basically demand that a defense lawyer when they bring this kind of thing to them. I think it's and if we don't, we're just fooling ourselves completely, and we're setting ourselves up for a disappointment. We have to understand the process just as much as we need to understand the process of what's the standard operating procedure when the police find a suspected dead body? Well, it's to call the freaking coroner and let the coroner make the decision whether they want to bring in more resources or not. It's just that simple to me. And that's the way that I've read the statute and understand it, and others have explained it to me. So, big thanks, Travis. Hopefully, we can come back again soon. Now, moving forward, tomorrow we're going to have Amy on. Foul Play's going to try to help her get Ashley Garth's case rolling. This is something that a case that's near and dear to her. And, she didn't understand the process of YouTube and how it works and presenting documentation. I'm going to help her do that. Tomorrow we're going to have her on at 5 Central. She sent me some documentation that we're going to go through. We're going to put it up on the screen and talk about it and let her explain this case is complicated. I'm going to tell you that right out the gate. And, my advice to her has been pick an area, a singular area, and explain it and move before you move to if you try to explain the whole thing, it's going to get messy and muddy and it won't hold your attention. So start with an area and explain it and move to the next area so it flows. So hopefully we can get that started. And then probably coming up for next week's open mic, as I promised, we're going to go back to Brendan and the en banc. And we're going to listen to the hearing and talk about his case and the decisions that were made, how they got there. Hopefully, Travis, you can be a part of that. You're certainly invited to come and talk. From a legal standpoint, you know far more than we do. And maybe you can help us do that. So, the invite's always open. You're always welcome to come. But, for the en banc, I think we all experienced a lot of disappointment in how that went. But, we have to, I think as a group that's interested in these cases, that we have to accept what it is and whatever next steps are moving forward down the road. But I think, for Brendan, I think we should do that. And so that's what I'm going to do next for the next open mic. And with that, unless anyone has any, the link. I have dropped the link for tomorrow's open mic in the chat a number of times as well. So I hope everyone can join us. And listen to what Amy says about Ashley's case. It's really interesting. her public defender was terrible. I mean, terrible. And so I'm sure Ashley will Amy will tell us more about that. So with that said, I want to thank everyone that's been in the live chat and listening, asking questions. Keep them coming. Let's keep this case. Yeah, go ahead, Rhonda, please.
I'm butting in. Don't go yet. I just want to remind everybody I will be going live Tuesday night at 5 p.m. Central, and we will be reading preliminary transcript from Rosetta Great's pre-trial hearing.
Oh boy.
So,
my God.
Join us Tuesday at 5 p.m. Central, and I'm going through it now, and she's a character.
Does Scott Adams make an appearance?
Well, yeah, he's the only attorney that does any cross-examination. You don't have to. I can get somebody else.
No. Scott's me, and I will be, of course, restreaming Rhonda's. I apologize for forgetting to mention I had it in my mind, and it just, I don't know, brain. Well, I'm pretty hungry. I know you probably are too. So.
Yeah. Yep.
Yeah. So.
Yeah, Jack will be streaming. Yeah, go ahead.
Yeah, I'll be restreaming Rhonda's channel and reading Scott Adams' part as well. So, anything else?
Sorry.
No. I forgot. You're right to smack me on top of the head. I deserve that. So, anyway, thanks again to everyone that's joined us. If you like what we're doing, give us a like, a subscribe, and a share. If there's something else you want to talk about, let me know. That's what the open mic's for. So, and please join us in Discord to continue the discussion. With that said, hold on. With that said, I'm going to say this has been a Foul Play production.
Bye, everybody. Good night.
Good night.